Good afternoon, everybody. Sorry I'm a little late. It's been a crazy day around here, but I am going to start the audio of the broken plea. This is going to be the last of it. There's 2 hours and let's see, 2 hours and 18 minutes left, and I have it on 1.5. You can slow that down for yourself. I did it this way so that it goes faster. I think I had it on 1.5 the rest of the time. I can't remember. Do y'all remember? I don't remember if it's 1.5 or 1.2. Let me go look real quick. Mm-hmm. I don't think I sped this last one up. I think it's just like it was before. That's odd. Let me look at the first one. Y'all bear with me. I'm trying to get this figured out. That one is the same way. That one says 1. So I'm going to do it at 1.2. And we're just going to do the best we can. All right, so we are on chapter 13, Othram Laboratories, ibuprofen, and I can't read the rest of it. That is where we're starting. All right, here we go. I'm going to mute. I'm not going to commentate, and I'm going to be up doing things. So I'm not going to be monitoring the comments, just FYI. I'm way past losing it. Way past losing it. That is for sure. All right, here we go.
Chapter 13, Othram Laboratories, Ibuprofen, Dylan's Green Jacket. Forensics is a catch-all term used to describe just about any scientific test, inquiry, or examination. Police often rely on it in the analysis of physical evidence, such as blood spatter, wound ballistics, and toxicology. But there are other applications too. Detectives in this case used forensic techniques to dissect everything from cell phones and laptop hard drives to social media activity, motor vehicle registrations, cell tower pings, and accounting. They pored over autopsy reports, surveillance camera footage, DoorDash deliveries, text chains, group chats, and emails, the bar tabs of corner club patrons on Saturday night. After 3 years and tens of thousands of man-hours building files full of 500,000 items, the state of Idaho's entire investigation can be grouped into just 2 categories: a few human cells found in Maddie Mogen's room and everything else. In very simple terms, the case against Brian Kohberger seemed to hang on the forensic examination of a K-bar knife sheath and a tiny sample of DNA. For the record, we are talking about a sheath, not the knife itself. No murder weapon has ever been recovered, and the prosecution has never once claimed to know exactly what produced the, quote, edged weapon, end quote, injuries inflicted upon the victims. Though media speculation has tied the sheath and wound characteristics to the K-bar's flat-top blade, the defense claims evidence of 4 separate instruments. Yes, prosecution files show the defendant owned a K-bar knife, but only because somebody ordered one on Amazon using a gift card and had it shipped to his parents' house in Pennsylvania. Autopsy reports detail various depths of intrusive injuries that are labeled by the coroner as 2-edged, single edge, and round. Other than the steak knife Hunter Johnson took from the kitchen, no brand, type, or specific item has been named. No crime lab has ever matched them. Before we start down that long, torturous path of validation, we need to look at what Bill Thompson told us. On July 2nd, 2025, he stood in Judge Hippler's Ada County courtroom and summarized the state's only physical evidence in 2 sentences. To this day, no transparent accounting of the DNA's provenance, methodology of testing, or disposition has ever been offered. The defendant, Thompson said, as he left that room, for whatever reason, ended up leaving where the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. That sheath was tested by the Idaho State Police Forensic Lab, and single-source male DNA was found on the snap of that sheath. This was moments before the defendant changed his plea to guilty, of course, so we will stipulate that months of analysis by the FBI's finest genealogist reduced thousands of data points from hundreds of tests conducted on dozens of exhibits into one plausible conclusion. Brian C. Kohberger broke into 1122 King Road on November 13, 2022, and killed 4 strangers in less than 4 minutes, barely leaving a clue. Only forensics kept this from becoming a perfect crime. Perfect crime? Asked Dr. Turvey in a second interview conducted by the author in December 2025. Let me be clear, he said. There is nothing about these murders that was even remotely perfect. No matter what the prosecution wants you to believe, this thing was a mess. We don't know if that scabbard was found on the floor or in the bed. We don't know who placed it in the bag, so we don't know where the bag went either, or who handled it. We don't know which sample the FBI actually tested because it was sent to a private lab in Texas first, and in my view, they appeared to have been fired by the ISP because their results did not match what the prosecution wanted to hear. The truth is, we don't even know how the FBI tied the DNA to Kohberger because it sure as hell wasn't CODIS, and it is illegal to use commercial sites. So you tell me, what exactly is it about these crimes that you would call perfect? Unpacking this statement will take some time, but we'll get there. Before we do, it is important to note that much of Turvey's ire is based on terabytes worth of information that he has seen and we have not. When Kohberger pleaded guilty, he offered no allocution, meaning Bill Thompson's 54-word explanation is all we know about the evidence stacked against him. To this day, it would be extremely difficult to look at piecemeal FOIA disclosures and make sense of diluted bloodstains in the living room and signature wounds inflicted post-mortem on Maddie's and Kaylee's carefully posed bodies. Blood spatter analysis makes it nearly impossible to know where Xana was first attacked, why Ethan never got up to defend her, how she fled for her life from the kitchen to her room as the killer tossed Maddie's and Kaylee's blood all over the walls without getting a single drop on the floor. No one has ever explained why the bloodstains on the top half of Xana's bedroom door look different from those on the bottom. The prosecution has never explained how one killer inflicted more than 65 wounds on a woman as she fought for her life just 3 feet from a 6'4" boyfriend who never got out of bed. In his statements to the court, Bill Thompson did not mention that Ethan Chapin died with a chunk of hair in his fist that was labeled as debris by the lab. Most disturbing, perhaps, is the fact that no one has explained how Ethan's undiluted blood was found at the top of the stairwell leading down to the first floor. The prosecution's own reports show that once attacked, he never left Xana's room. You know the biggest travesty in this whole thing? Turvey asked midway through a conversation about what he felt were the problems inherent in Thompson's case. When Ann Taylor's office questioned how DNA on the knife was tested, the prosecution fought her, tooth and nail. Look at the Franks hearing transcripts. Look at her discovery filings and the prosecution's motions to suppress. They fought tooth and nail to keep her from finding out the most basic information about what boils down to their only real exhibit. I've never seen anything like it. It should be noted that among 4 expert witnesses interviewed by the author for this book, Dr. Turvey is one of only 2 who consented to his name being used. Most important, we should consider that without leaks from disgusted experts like Turvey, the public would not have known about possible chain of custody issues with the K-bar sheath or apparent discrepancies about where it was found. They would not be aware that Paulette Sutton explained the lack of DNA in the defendant's car by suggesting he had shed his blood-soaked clothes and ran around the house naked. They would have no idea the police seemed not to care that the first floor bathroom had been sanitized and was found completely empty of things a college student might use in day-to-day life. Staples like a toothbrush, a hairdryer, floor mats, discarded clothes, towels, makeup, toothpaste, a razor. There was no toilet paper at all. They would not know about a broken woman's bracelet found on the floor of the empty first floor bedroom, that it appeared to be stained with blood, but was never tested or even seized as evidence. Worse, they would have no idea that police found a green, blood-soaked jacket in that same room, or that it was handed to Dylan Mortensen as personal property according to the police report, placed in storage, and only found by Ann Taylor weeks after the fact. They would not know the blood on the jacket was tested by an independent lab called Bodie Technology, which found a mixture of DNA they could not analyze further, except the part that was Dylan's. First, we need to discuss the basics of what got defense experts like Turvey so riled up. According to sealed court filings, Ann Taylor's office approached the court requesting a Franks hearing. This legal proceeding is named after a 1978 Supreme Court case, Franks v. Delaware, which allows a defendant to challenge the truthfulness of a search warrant affidavit. To be granted such a hearing, Taylor's office had to make a, quote, substantial preliminary showing, end quote, that the law enforcement affidavit included a false or misleading statement. Here, the warrant in question involved DNA, and Taylor must have checked prerequisite boxes because the hearing was granted. Taylor's burden was to prove that the affidavit's author, quote, either knowingly, intentionally, or with reckless disregard for the truth, end quote, failed in stating probable cause. If she had been successful, evidence obtained under the warrant would have been suppressed. Spoiler alert, she was not. At this point, however, that does not matter, because admissibility of evidence is moot when the defendant pleads guilty. What Taylor accomplished when she stood before Judge Hippler on January 23, 2025, was exposure of what, in my opinion, might indicate a pattern of official wrongdoing. Though no jury was ever supposed to hear Taylor's objections, we will review them here. This is what so incensed Dr. Turvey and his peers. Let's go on the record in State v. Koberger, CR 0124316665, Judge Hippler says, setting the stage at the beginning of these closed proceedings. Present in the courtroom today are the defendant with counsel, Ms. Taylor and Ms. Massoth. Is Mr. Logsdon here? Mr. Logsdon is here, Taylor responds. For the state, we have Mr. Thompson, Mr. Nye, and Ms. Jennings. Yes, Your Honor, the chief prosecutor affirms this is his team. After a few procedural exchanges, Ann Taylor calls her first witness, MPD lead detective Brett Payne. He is sworn in, and things get down to business. When was the first time you heard Brian Koberger's name? She asks after a series of questions about his job and background. At that point in time, he was a corporal with police officer standards and training, post certification, and about 7 years on the job. Prior to that, he had been military police. The first time I heard Brian Koberger's name was December 19, 2022, he said. And what was that a result of? That was a result of investigative genetic genealogy that was being undertaken by the FBI. We had a phone call that evening, and we were told Brian Koberger's name. And before that, she asked, Mr. Koberger was not on your radar? No, ma'am. This is a critically important statement because according to MPD reports, no one started looking for a white 2015 Hyundai Elantra until December 26, a full week later. And that was supposedly due to a WSU officer stumbling onto it in parking registrations. According to Detective Payne's sworn statement, Koberger had, quote, appeared on his radar, end quote, well before the FBI revised its analysis of the mysterious white sedan from a Nissan Sentra to a Hyundai manufactured between 2011 and 2013. If we are led to believe that WSU police just happened to spot Koberger's car a week after the detective in charge of the investigation learned his name, it is a significant stretch of credulity. At what point did experts finally decide they were looking for a 2015 Elantra? Before December 19, was the FBI CAS team member collocated with you? Yes, ma'am. According to Payne's sworn statement, he somehow learned about Koberger from an FBI CAS member, not from identification of his car, as has always been believed. If true, this changes the prosecution narrative entirely. How long had he been collocated with you? I don't remember exactly, but it had been several weeks at that point. And was that Nicholas Balance? Yes, ma'am. What other FBI team members were collocated with you? Goodness, he said, a lot. We had technical assistant Maria Tyndall, S.A. Jacobson, and numerous other FBI special agents that were there to assist. For those wondering what this has to do with DNA, remember that the whole point in a Franks hearing is to demonstrate false statements by an affiant in the presentation of a search warrant affidavit. Taylor clearly had a target in mind, and Payne was part of her foundation. Remember, we are looking at the state's only physical evidence, DNA. Did you have any role in deciding to pursue investigative genetic genealogy? She asked. Yes, ma'am. It was a collaborative decision among the command team to go that route, but yes, I was a part of it. Were you a part of the discussion during the process of identification? Yes, ma'am. Were you aware that Othram Laboratories began the work on the investigative genetic genealogy? Yes, ma'am. What kinds of information did you receive from Othram Laboratories? I don't remember what was received from Othram directly, he says. I knew they were conducting their specific type of work. I don't remember exactly what they provided us. And here we stop the presses. What Ann Taylor believed she knew, and almost everyone else did not, is the police may have identified Koberger as a person of interest well before they supposedly stumbled onto his car. The lead detective, Brett Payne, had just sworn under oath that he learned about Koberger from specialists from the FBI. They had decided to, quote, go that route, end quote, with genetic genealogy, and they had done it not through the Idaho State Police Lab, but a private company in Texas. Remember, according to Bill Thompson, at Koberger's change of plea hearing, the K-bar sheath, quote, was tested by the Idaho State Police Forensic Lab, and single-source male DNA was found on the snap of the sheath, end quote. Though not widely known, records show that police also contacted a Department of Defense representative through the FBI Salt Lake City Division on December 1, 2022, seeking to determine what would be required to have the K-bar sample run through the DoD's repository. It seems clear where Taylor is headed. Did you receive any documents from them? Yes, ma'am. Okay. Do you know how many documents received from them? I do not. Was it one time or more than one time? I don't remember. Detective Brett Payne is the detective in charge of the MPD investigation. This is the defining exhibit in his case. It seems like something he would remember. Were you part of the discussion to take the work from Othram and go to the FBI? Yes, ma'am. Why was that decision made? From my understanding, granted, this is my first encounter with investigative genetic genealogy. So again, as a collaborative discussion, we decided that because the Idaho State Police Lab and Othram had essentially exhausted their resources, this is how I understood it, that we would move to the FBI because they had more resources available to pursue this particular avenue. Do you know what more resources the FBI had? The only thing I'm privy to was that they had more databases that they could compare the sample to. That was the extent of my knowledge. And though we will return to Payne's testimony in a moment, we need a little context. According to a June 22, 2023 filing by Ann Taylor's office, we know that the Idaho State Police announced on July 28, 2021, that they had received a Bureau of Justice Assistance grant to fund genetic genealogy testing through a company called Othram, a private Texas forensic laboratory. In the press release, the Idaho State Police specifically mentions that Othram, quote, follows accepted laboratory processes and procedures and complies with the United States DOJ interim policy on forensic genetic genealogy, DNA analysis, and searching, end quote. This will prove critically important moving forward because Ann Taylor is about to allege that Othram was fired when they developed a single-source male DNA profile on the K-bar sheath but could not match it to Koberger. What was your communication with the FBI about the IGG? Taylor asked after a couple of administrative questions. Remember, IGG stands for Investigative Genetic Genealogy, a relatively new branch a forensic analysis in 2022. To be clear, Ann Taylor's line of questioning is implying that Brett Payne, the lead detective in charge of the case, knew about the Idaho State Police shopping his DNA evidence in search of a predetermined match. If she is correct, the impact on Thompson's case would have been seismic. So our communications were just via telephone, he responds. The sample was sent to the FBI. I don't remember the date it was given over to them, but after that, there were very few conversations. And if they happened at all, they were just telephonic, advising us that the process was still in the works and they would let us know when or if they had anything of interest. Again, Ann Taylor has established that the MPD sent the K-bar knife sheath, with DNA found on it, to the ISP crime lab for analysis. From there, it was sent to Othram, the private lab in Texas. At some point in December 2022, the ISP discontinued their work with Othram, retrieved the evidence, and sent it to the FBI lab in Quantico, Virginia. According to Payne, the motivation boiled down to, quote, database size, end quote. What Taylor wants to prove is that police already believed the DNA belonged to Brian C. Kohberger, but did not have a large enough pool of comparables to prove it. They fired Othram and sent their sample to an agency that did. Do you know what files or documents went to the FBI from Othram? She asked. I do not remember. This is the biggest murder case in Idaho history. Payne is the detective in charge. The sheath is the single most important piece of physical evidence. He testified that he does not remember. Did you receive documents from the FBI? She asked. In relation to the IGG? Yes. I believe after the fact, after we received Kohberger's name, we did receive documents, but I don't remember what they were. At that point, Taylor asked what happened once police learned Kohberger's name, and from there things get interesting. So, the only thing that was given to us was Brian Kohberger's name. That was it. It was conveyed to us by the FBI that it was to be taken as no more than a tip. That was it. So once we received his name, we set about doing basically an independent verification of whether or not he was involved in this crime. Oddly enough, Taylor does not follow up with what seems to be the obvious question. In what reality would DNA identification of a killer by the FBI be treated as, quote, no more than a tip? And how is it possible that Payne had already told her he learned of Kohberger's name from the FBI cast member 1 full week before they coincidentally identified his car? Suddenly, the prosecution's entire narrative seems to be crumbling. I'm going to talk to you about that and a little bit more, Taylor continues. But do you know why the FBI connected Brian Kohberger to the case? So, December 20, if memory serves me, he said, we had a secondary meeting with the FBI via Teams, if memory serves, and they simply walked us through the family tree. How they did that. Now, I don't remember the details of all that. It was an in-depth conversation that, to be honest, is above my head. But they essentially worked their way through the family tree and arrived at a conclusion that Brian Kohberger was a person we should look into as a tip. That's the extent of my knowledge of how they did that. How is Brian Kohberger, she asked, the name you received as a tip, linked to the case? He wasn't until after December 19. What item of evidence did they link Brian Kohberger to? I'm not sure what you're asking, Payne said. As far as before December 19, is that what you're referring to? Yeah. We didn't have one at that point. Why did you become interested in learning the identity of Brian Kohberger? Not quite sure I understand your question, he said. We were interested in anyone who would have been involved in this. The DNA from the knife sheath was obviously the one thing we had that we thought was a very strong piece of evidence in this case. So it was that particular piece that we pursued as a potential avenue of identifying a suspect. Is it your understanding that the FBI's work said that it was Brian Kohberger's DNA on the sheath? That is not my understanding. What is your understanding? My understanding is that the FBI concluded that Brian Kohberger was a possible source of DNA that we should look into. They did not, to my knowledge, at any point say Brian Kohberger's DNA is on the knife sheath. That was never conveyed to me. For those unfamiliar with 3 years of media coverage, this is the lead detective in charge of the case stating plainly, under oath, that to his knowledge, the FBI never said they found Brian Kohberger's DNA on a knife sheath. How is it possible that after 3 years of assurances from Latah County Prosecuting Attorney Bill Thompson that the DNA proves guilt beyond a reasonable doubt, his lead investigator states, under oath, that it did not? To make sense of this, and Ann Taylor's entire line of questioning, we need to go back to predicate motions. On September 1, 2023, Taylor's office filed a document titled Response to State's Notice of Intent Not to Cross-Examine Defense Witnesses, District Court Decision, and Records to Explain Witness Contact. Though the heading seems a bit confusing, the argument is simple. Taylor believed the methodology employed by the FBI was flawed. Despite disclosure mandates provided in Brady v. Maryland, she seemed to believe that Bill Thompson's office had deliberately withheld exculpatory information crucial to the defense of her client. She wanted answers. She wrote, "Counsel has learned, through consultation with experts and sources referenced below, that the use of genetic genealogy databases does not necessarily lead to a single individual as a potential suspect, and that reports of these searches often reference multiple individuals for further investigation and DNA testing. In fact, the state acknowledges such in its motion for protective order when it acknowledges, quote, hundreds of relatives, page 5 of the motion for protection order." In very simple terms, Taylor is suggesting that the prosecution's claims may not be true. The testing conducted by a private lab is completely different in nature than the testing done by forensic labs. Genetic genealogy labs do not generate a profile in the same way that forensic labs do, and there cannot be a direct comparison between the data obtained in this case by the Idaho State Forensic Crime Lab and the private lab. The tests used by private labs are either SNP, single nucleotide polymorphisms, or whole genome sequencing. These tests are similar to the methods used by commercial services such as 23andMe and Ancestry.com. Based on this, it seems plausible that the defense believed, 4 months prior to the Franks hearing, that Bill Thompson's office had deliberately misled the public about the K-bar DNA. Evidence would suggest he knew about possible problems with the chain of custody, about the Idaho State Police shopping results between Othram and the FBI, and that based on IgG methodologies, he would face real challenges tying Kohberger to the sheath at trial. Most important, Taylor appears to believe that evidence Bill Thompson touted as the foundation of his case may have been misrepresented, mishandled, and hidden from scrutiny by the court's own rulings. While the prosecution trumpeted news that Kohberger's DNA had been found at the scene of the crime, Taylor disputes it. Though few among us hold PhDs in forensic genealogy, the United States Department of Justice does a pretty good job of explaining Kohberger's defense. In 2011, the DOJ published its interim policy on forensic, genetic, genealogical DNA analysis and searching, laying out acceptable standards and methodologies in criminal investigations. This is the same document Ann Taylor cited at the Franks hearing, a lucid explanation of where the prosecution might have gone wrong. We will not quote the entire document, but excerpts warrant citation. STR, DNA typing, and CODIS. Forensic DNA typing has historically been used to compare 13 to 20 STR DNA markers between a forensic sample and one or more reference samples. When a suspect's identity is unknown, a participating crime laboratory may upload a forensic profile into the FBI's Combined DNA Index System, CODIS. CODIS is a law enforcement database that compares DNA profiles derived from forensic samples to those of unknown offenders. CODIS was created by the DNA Identification Act of 1994. This legislation authorized the FBI to create and maintain a national database comprised of designated DNA indices that are routinely searched against one another. If a CODIS search results in the confirmed match between a forensic profile and a known offender, a law enforcement lead is generated and the name of the matching offender is released. If the search does not result in a confirmed match, no lead is generated. Forensic genetic genealogical DNA analysis and searching. Forensic genealogy is law enforcement's use of DNA analysis combined with traditional genealogy research to generate investigative leads for unsolved violent crimes. Forensic genetic genealogical DNA analysis, or FGG, differs from STR DNA typing in both the type of technology employed and the nature of the databases utilized. FGG examines more than 500,000 single nucleotide polymorphisms, or SNPs, which replace the STR DNA markers analyzed in traditional forensic DNA typing. These SNPs span the entirety of the human genome. This allows scientists to identify shared blocks of DNA between.
Okay, open your eyes, peeps. If it's not Brian, is that just an amazing, amazing coincidence that a white Elantra goes into that dead end neighborhood 5 times from 3:30 to 4:07 a.m. and then speeds away just before 4:21 a.m.? Oh, it's absolutely not a coincidence. I don't believe in coincidences. However, can you prove that it's an Elantra? Can you prove that it's Brian Koberger driving it? Can you prove anything that connects Brian Koberger to that car that goes into the neighborhood 5 times from 3:30 a.m. to 4:07 a.m.? What evidence do you have that connects him to that car? Do you ever at any point in time see him in the driver's seat? Do you see him entering or exiting the vehicle? Do you see any identifying marks? Because the prosecution's expert witness says he does not. And even if it is him in a car, what fucking difference does it make if he's out driving his car around? That doesn't make him a quadruple murderer. What evidence do you or anyone else have that puts this man in that house? I'll wait. I know I said I wasn't going to commentate, but this is YouTube, and I can respond however I want to, and I was not missing the chance. Waiting. Why are you quiet now? Nobody blocked them, did they? Because I can't see if somebody's been blocked. Did you just come in to say you're one hit wonder and have nothing else to say, or? Um, did you not just listen to what this man said? His DNA is not on the knife sheath. Have you completely missed all of this new information? Brent Turvey has went live on 2 different channels explaining the DNA. It is connected to the 4 biological brothers whose blood is on the handrail leading down to the first floor, not Brian Koberger. The Franks hearing said it was a good investigative lead, but was not enough proof because it does not directly connect Brian Kohberger to the knife sheath. And the knife sheath was originally found on the fucking floor. It's brand new, never been used. As Brent Turvey says, pristine, looks like it just came out of the package. There's no blood smears on the knife sheath when it's shoved under Maddie's leg, which means the blood on the sheet would have been smeared. Well, your understanding is incorrect. Turvey, it isn't his book. He didn't write the book. This man did. Get your information correct. Christopher Whitcomb wrote the book. Brent Turvey is one of the most renowned forensic scientists in the entire effing world. His integrity is unquestionable. None of that proves he was there. None of it. It's all circumstantial. And if you think that he did all of this in under 12 minutes and then cleaned the fucking house too, position the bodies, do some fucking research. Of course, it's going to look new. He bought it in March. This happened in November. I swear to God, people are daft. Here's the thing. And this is exactly, Brent Turvey said this in one of his interviews. People don't care about facts. People don't care about evidence. They get one idea in their head, and that is all they care about. See, people like you don't care who actually did this. You don't care if the actual perpetrators are behind bars. You don't care if the actual perpetrators are held accountable. You just care about the narrative that's been spun since jump. Well, I'm not talking about Whitcomb. I'm talking about Turvey, because Brent Turvey is who I base my knowledge on. Because there is not one thing that man says that I do not believe. And the fact that you are ignorant and immature enough to talk about a pro burger, let me open your eyes for a minute, fuckwit. I don't give a fuck if Brian Kohberger stays in prison for the rest of his life. Don't give two fucks. Don't give one fuck. Don't give any fucks about Brian Kohberger. What I care about is justice for the victims. And if he's guilty, then let him lay in there and rot. But what if he's not? What if he's not? With all of this evidence that proves that someone else was there, what about the hair in Ethan's hand? You don't believe there was any cleanup, dumbass? Every piece of blood there was diluted. You're a fucking idiot. An abso-fucking-lute idiot. That shows me right there that you don't know one fucking thing about the evidence. You know nothing about this case. Nothing. You're an idiot. She also had no time to have defensive wounds, fight back. There were 150 stab wounds. 150 stab wounds. Kaylee Gonsalves was beaten unrecognizably. There is bloody hair on Maddie's side of the bed between her legs that belongs to a female. There is a round 5 clumps of hair beside Kaylee's leg. What we are is pro-truth. And unlike you, we have the common sense and intelligence to question things that don't make sense. We don't just believe whatever someone tells us. And you think that this man inflicted over 150 stabs and didn't leave a bloody footprint any fucking where in that house? Not one. You think he didn't leave any DNA behind other than a knife sheath that wasn't under Maddie's leg until after the first responding officers? That makes absolutely no fucking sense. What you just said makes absolutely no sense. We don't even know if that knife sheath is connected to the weapon that was used, or weapons, I should say, because there were at least 3 that were used on the victims. Were you aware of that? Were you aware of that? 3 of the 4 victims, you were correct. So was Ethan, whose legs, the backs of his legs, were slashed in 4 places, actually. 2 on one leg, 1 on the other, to the bone, and 1 in between his legs. Where's that blood? Because it's not on the bed. He's wearing completely white, pristine socks. Not 1 drop of blood. Not 1. Where's that blood? Well, see, open your peeps. Here's the thing. The officer doesn't have to notice it because their body cam caught it. Both of the first responding officers, both Nunez and Warner, their body cams, the unredacted body cams, show that there was nothing under Maddie's leg when they got there. But miraculously, it ends up there in the crime scene pictures. So please explain to me how that happened. Oh, wise one. Is it a disappearing sheath that only appears to certain people at certain times? And okay, let's say you're right, that the knife sheath was under her leg. Well, then let's see the lividity report. Where is the lividity report that would show the void underneath Maddie's leg to prove that that knife sheath was under there the entire time and not shoved under there haphazardly after the police got there? Where's that information? Because that is scientific evidence that cannot be changed. Where is it? Because that would prove your case. I don't drink Starbucks. And I don't make stupid bets. The only thing that I care about is the facts and the evidence. The only thing you care about is the narrative. The camera angle. Have you seen the videos? Because that was actually one of the questions that was asked to Brent Turvey. And there were 2 separate body cams from multiple positions within 18 inches of Maddie's body. And it is not seen on any of the frames of the video.
Like it's your job, hosting.
Speculative versions? Are you really that fucking stupid? Speculative? You're a dumbass. He wrote all of this in his damn report before him and Ann Taylor ever had any issue. You're a fucking idiot. A true fucking idiot, just like all the rest. You don't care about the truth. You care about what makes you feel better. Well, I hope that makes you feel better, going to bed thinking that somebody's guilty when you don't know for one fucking minute if it's true or not. And you certainly don't know a fact from delusion, which you seem to have a lot of. No, I haven't seen the body cam footage, but Brent Turvey's word is all I need to hear because I have followed that man for decades. Decades. And if you knew anything about him like I do, you would know that he has never gone public like this about a case. Ever. But continue your delusions. Keep believing the dumbasses who don't know their ass from a hole in the ground, and the police who've lied from jump, and all the others who profess to be experts in this case who don't know their ass from a hole in the ground. Sort of like you. Oh, I don't have kindness in my heart for dumbasses like you. Not at all. Have no kindness in my heart for morons. Don't have the tolerance nor the patience. Because I'm focused on justice for the victims of this case. Not a narrative that somebody has taught me. I don't care about court at all. Don't care two shits about court. I'm not even sure where court comes into this. I care about the truth. I care about accountability for the people who actually did this. And if you follow the actual facts and evidence of this case, there is not one single thing, not one, that proves anything about Brian Kohberger being in that house. I actually know the dimensions. Would you like to know them? No, what I'm saying is I don't have to see the body cam. Because I know enough about Brent Turvey's character and integrity to know that if he says something, you can believe it. Stake your life on it. Because that man has always been focused on integrity and truth. Which is exactly why he is one of, if not the most renowned forensic scientist in the world. Who cares about an Elantra? That Elantra doesn't prove anything. Here's what I'll say to you. And this is the last thing because my boyfriend's about to go live and I need to be there. But I will say this. Enjoy your ignorance. Enjoy it. And just as Brent Turvey said yesterday or day before in his interview, if the Justice Project took this case on right now and tested the DNA the same way that Othram did, Brian Kohberger would be free. What's a little troubling is willfully ignorant people like you. That's what's wrong with the world. And you're focused on a fucking car instead of the fact that there's no evidence that the person who's behind bars is there. Now fuck off and go eat a dick. And now I'm going to play this because my boyfriend's live. Today is our 11-month anniversary, and I'm going to celebrate.
a forensic sample and the sample donor's potential relatives. Recombination or reshuffling of the gene genome is expected as DNA from each generation is passed down, resulting in larger, shared blocks of identical DNA between closer relatives and shorter blocks between more distant relatives, due to predicted levels of recombination blocks of genetic information and make inferences regarding potential familial relationships. Limitations. If the search of an FGG profile results in one or more genetic associations, the GG service typically generates and provides the service user with a list of genetically associated service user names, along with an estimated relationship, and in some cases, the amount of DNA shared by those individuals. A genetic association means that the donor of the forensic or reference sample may be related to a service user. However, information derived from genetic association is used by law enforcement only as an investigative lead. Traditional genealogical research and other investigative work is needed to determine the true nature of any genetic association. A suspect shall not be arrested based solely on a genetic association generated by a GG service. If a suspect is identified after a genetic association has occurred, STR DNA typing must be performed, and the suspect's STR DNA profile must be directly compared to the forensic profile previously uploaded to CODIS. This comparison is necessary to confirm that the forensic sample could have originated from the suspect. Case criteria. Investigative agencies may initiate the process of considering the use of FGGs when a case involves an unsolved violent crime and the candidate forensic sample is from a putative perpetrator, or when a case involves what is reasonably believed by investigators to be the unidentified remains of a suspected homicide victim. In addition, the prosecutor, as defined in footnote 20 of this interim policy, may authorize the investigative use of FGGs for violent crimes or attempts to commit violent crimes other than homicide or sexual offenses, while observing and complying with all requirements of this interim policy when the circumstances surrounding the criminal acts present a substantial and ongoing threat to public safety or national security. Before an investigative agency may attempt to use FGGs, the forensic profile derived from the candid forensic sample must have been uploaded to CODIS, and subsequent CODIS searches must have failed to produce a probative and confirmed DNA match. In the interest of full disclosure, it should be noted that the author of this book worked as a chief advocacy officer for a Colorado company called Andy, developing use of, quote, rapid DNA technology in criminal investigations. I have lobbied at both state and federal levels for legislation expanding use of DNA technology, and I have worked extensively with former FBI colleagues seeking private access to CODIS. That said, the problem with using DNA for identification is that what you get out is only as good as what you put in. It gets confusing. The primary issue is that scientists match genetic material using two primary methodologies. One is available to regular people who are looking to build family trees on commercially accessible sites like Ancestry.com. The other is limited to law enforcement trying to match evidence found at a crime scene to the person who left it. That kind of forensic DNA identification is the domain of the FBI by a submission to its CODIS database. Based on information gathered by Ann Taylor and probed at the Franks hearing, she believed police had tried to identify her client through CODIS, and when that failed, they may have violated DOJ policy by using two private databases, GED Match and MyHeritage. This is what is referred to as investigative genetic genealogy. Returning to the Franks hearing, I believe that she was right. Will you please state your name for the record? Ann Taylor asked. She has just called her second witness. Rylene, R-Y-L-E-N-E, the witness states. Nowlin, N-O-W-L-I-N. I think you've done this before. A few times, she says. Rylene Nowlin is next up, after Brett Payne, who just testified under oath that the FBI never said they found DNA from Taylor's client on the K-bar sheath. In January 2025, Nowlin worked as a forensic manager at the ISP Forensic Services Laboratory in Meridian, Idaho. She had worked there for 23 years, originally hired as a scientist in the biology DNA unit, based on formal education and training in genetics, molecular biology, biochemistry, and statistics. She completed the ISPFS Specialized Training Program in Biology Screening, DNA, and DNA Database Analysis. She was a member of the Northwest Association of Forensic Scientists, the American Society of Crime Laboratory Directors, and the National Technology and Validation Implementation Collaborative. Suffice to say, she's smart, accomplished, a leader in her field. Would investigative genetic genealogy be a new technology? Taylor asks. That is one of the technologies, Alan answers. However, our group refers to it as FIGG, Forensic Investigative Genetic Genealogy. FIGG. Okay, Taylor responds. I'll try to remember that. That's the one I want to talk about today. So, your group is talking about best practices for FIGG, is that right? That's one of our areas of focus, correct. Are you doing that because there are practices that are important in this discipline? We are doing that because it's a new technology coming into the forensic world, and not every laboratory manager has a background in DNA. You do not need a law degree or years in law enforcement to see where this is going. Ann Taylor has staged this hearing because she has specific information regarding the prosecution's assertions that her client's DNA was found in Maddie Mogan's bed. Tell me what CODIS is, briefly, Taylor asks after a few setup questions. CODIS, Combined DNA Index System, is essentially a national DNA database. It exists on 3 levels. There's a local level, your county sheriff's office, local PDs. There's a state level, which is typically the state laboratory. It is limited to public laboratories, and then the national level. Biometric identification has evolved since the 1980s, when the FBI kept 3 by 5 inch fingerprint cards in file cabinets to be searched by hand. CODIS is an extraordinary resource. In Idaho, Nowlin continues, the Idaho State Police Forensic Services Lab in Meridian is the only DNA lab in the state, so there are no local labs in the state of Idaho. And the database contains different indices. There's a forensic index. Those are profiles obtained from items of evidence. There's an offender index. Those are samples from those convicted of qualifying offenses in your state as determined by your state legislation. If your state legislation allows arrestees, there's an arrestee index. There's also a missing persons index for remains. Taylor asks a few more questions, establishing that Nowlin previously served as Idaho's alternate CODIS administrator. She's laying the groundwork for a bomb everyone sees coming. For CODIS, DNA that goes into CODIS, what kind of profile is used? If I'm understanding the question correctly, Nowlin answers, there's different types of DNA profiles, and what goes into CODIS is known as an STR profile, or short tandem repeat. What kind of information is in short tandem repeat, or STR? So, DNA is a substance that's found in the cells of your body, Nowlin explains. It acts as a blueprint. It tells our bodies what form to take and how to function. Between individuals, it is over 99% the same. That is why we all have the same basic structure, and our bodies function in basically the same way. In forensics and in STRs, we are targeting that less than 1% that is unique to an individual, with the exception of identical twins. And so areas of DNA that vary widely between individuals don't code for anything typically, so it doesn't tell us anything about a person. When I look at an STR profile, I can tell you if that person is genetically male or genetically female, and that is all. Do you know what an SNP profile is? I do. What is that? An SNP profile is a single nucleotide polymorphism. So you're looking at a single nucleotide, whereas the STR is a series of repeating nucleotides, a specific repeat that we're looking for. The SNP, then, is that a closer look at a person's genome, Taylor asks? I would like to state that I'm not an expert in SNPs. I'm not qualified in the SNP technology and have not ever been qualified in the SNP technology. With STRs, depending on the chemistry, you're looking at anywhere from 13 to 25 plus locations. With SNPs, my understanding is in general you're looking at a minimum of 10,000. At that point, the prosecution objects to something about expertise, but Hitler overrules them. What might seem needlessly academic is actually the linchpin of the prosecution's case. You mentioned that there's 4 indexes, and you talked about a forensic index. Correct, Nowlin answers. What is that one used for? The forensic index is where profiles generated from items of evidence can be uploaded. There are rules about what can be uploaded, though. It cannot match someone known to be the victim of a crime. It cannot match someone whose DNA should be in a place outside of a crime being committed. It cannot be anything taken directly from a suspect of a crime where you would reasonably assume their DNA would be present. It must be related to a crime, and it must be believed to be from the putative perpetrator of that crime. So, if I understand it, you use DNA, get an STR, and only under certain circumstances can you use CODIS. Do I understand that right? Correct. And here she lights the fuse. Taylor asks Nowlin about her role in using investigative genetic genealogy and puts the lab manager on record as saying she developed the contract's scope of work, determining who won the bid. Did Idaho State Police Forensics have a contract with this laboratory, Othram? She asks. They were the winning bid through that process, and so they were under contract with the Department of Purchasing. Correct. Taylor asked a number of questions about administrative matters and obligations between the state of Idaho and the lab, but it all comes down to this. Ann Taylor knows that Othram Labs obtained the DNA profile from the K-bar sheath that was ultimately touted by the prosecution as Koberger's. Ann Taylor knows the police had already identified her client as a suspect in the case and believed the DNA on the sheath would come back to him. She knows that as a private laboratory, Othram could not query CODIS under the rules Nowlin previously stated. Further, she knows they did not have access to a public database large enough to match the sample with Koberger. She knows that when the Idaho State Police figured this out, they took the evidence back and sent it to the FBI. Were you aware that Othram was just stopped from doing any further work at some point, Taylor asks, going directly to the point? I was aware of that. And was this before they produced any result? No. We received a preliminary report. I recall receiving that because that's how I know I get approved payment of the invoice. So I know we received that prior to them being told they were stopped. Taylor is establishing that the ISP lab sent the K-bar sheath DNA to Othram, that Othram produced a preliminary report, and that shortly after, their work was discontinued. According to files reviewed by the author, it appears it was discontinued only in this particular case. Does the forensics lab continue to contract with Othram? She asked. Yes. Laying further foundation, Taylor asked Nowlin if she was made aware of a trash pull, the one we now know occurred December 27, 2022, at the Koberger home in Pennsylvania. Nowlin states that she was aware of the warrantless search and that she recalled being asked by detectives which items might be most likely to yield usable samples. The discussion was a person of interest had been developed and to analyze the items from the trash to determine if they could be inclusive of the DNA profile that was developed from the knife sheath, unknown male A, Nowlin explains. Unknown male A, of course, was Brian Koberger. Everyone involved in the case knew it at that point. They had him and his family under surveillance. What date was it that you received the trash? The trash was received into the laboratory on December 28, 2022. Taylor asked more questions about process. The lab manager seems to dodge them. Okay, when you got the trash to go through in the lab, you knew that you were looking for a male, right? Taylor asks. Correct. And you knew that the male and his family members lived in a house that produced the bag of trash. Is that right? The implication at this point is clear. According to Detective Payne's testimony, police had identified Brian Koberger as a suspect from an FBI cast member. They had used that information to narrow their search of white sedans from a Nissan Sentra to a 2011 to 2013 Hyundai Elantra, then to his 2015 model. According to Payne, Koberger must have been under investigation by December 19 because CAST was tracking his phone. It seems impossible that the detective in charge did not know Koberger's name until then. Something was not adding up. Which brings us to Ann Taylor's third witness at the January 23 hearing. His name was Matthew Gamet, and he was a laboratory system director with the Idaho State Police Forensic Services Division, overseeing administrative matters like procurement, contracts, and human resources. He had worked in that role for about 10 years. Let's talk about Othram being involved in the case that winds up being why we're here today. Taylor asked well into a series of questions, laying foundation that Gamet was fully knowledgeable of and involved with the lab. What communication did you have with Othram on the early end of that process? So, to my recollection, he said, our early communication on this case was providing them with DNA that they would be able to develop, hopefully, an investigative lead for us on a case. After that sample, to my knowledge, had been that we had followed our processes through and that we had put a sample into CODIS, that we had not received any hits off of CODIS, and then we would proceed with the next step of testing. We did have a contractual relationship with them since early in, I believe, 2021, and so we did have a contract with them in place. How did they get the DNA? The DNA sample itself, Gamet clarifies, that DNA sample was delivered by Moscow Police Department in person to them at Othram Labs. According to ISP Supplemental 56, Corporal Chad Williford transported the K-bar sheath from Moscow to the State Police Crime Lab in Meridian, Idaho on November 16, 2022. On the chain of custody form, his last name, for some reason, appears to be spelled differently as Willer Fawn. Did you have any role in that? Taylor asks. I accompanied the officer from Boise down to Houston and down to the Othram laboratory. I didn't have possession of the sample, but I was with the investigator that did. The evidence was transported to Othram on November 22nd. And when were they notified to stop work? I believe the notification, the official notification, was on December 10, if I remember correctly. The two talk back and forth about operational logistics and procedures using language of the trade like SNPs and YSTRs and wet work defined as, quote, anything that would be done in a physical laboratory. So after that, they have a recommendation for you, Taylor asks? Their recommendation, he clarifies, to my memory, to my recall, was that they had several individuals that had the potential to be of interest in this investigation. They asked us if, to further their family tree building, if we could be in contact with individuals and see if they were willing to contribute information into the database that they were using in order to further the family tree building and further the genealogical work. For the record, Gamut is telling Taylor that the Othram lab had identified several individuals based on DNA analysis of the K-bar sheath found in Mogan's room. And we're in a closed setting here, she says, so I'm going to ask you to give me the last name. I don't recall the last name, Gamut says. I'm sorry. Was it your understanding that these were four brothers? Yes. Okay. What did you do in relationship to these four brothers? So we did some cursory work, just looking into publicly accessible information, literally Google searches and things of that nature. What our approach was, is we didn't want to be approaching people, especially with an investigation of this nature, that really had nothing to do with anything. We just wanted to make sure there was some reason why Othram Laboratories was asking us to go and ask these individuals to put their DNA into the database that law enforcement can search. So we just did some work to build just very cursory family trees to see what connection these individuals might have and to verify these individuals were indeed brothers, things of that nature. Did you verify they were four brothers? Taylor asks. I don't know that I would use the word verify, but we believe that the information was reliable that they had given us based on the publicly accessible information. Now, I know you said you can't remember the last name of these brothers, Taylor says. We're here today, and Brian Koberger's name has been on the news for 2 years. You know his name. That wasn't the last name. That was not the last name, Gamut says. Taylor takes great pains to verify, for the record, that the first genetic profile developed by a state-contracted laboratory based on DNA found on the thumb snap, the K-bar sheath, was not Brian Koberger's. She asks what happened next, and Gamut tells her they contacted one of the four brothers who said he wanted nothing to do with the investigation. After that, things happened quickly. There was a meeting, to my knowledge, Gamut testifies, and I don't remember exactly when, but probably the morning of December 10. And we had a meeting, telephonic meeting is my memory, with representatives from Moscow Police Department. I believe FBI had representatives on the phone call, ISP, I believe myself, ISP, legal counsel, and I believe that the colonel of state police was on that phone call. What happened on that phone call? In that phone call, we were asked to turn over any kind of investigative records that we had, any kind of information that we had to the FBI team. They provided me with an email address to be able to provide what they were requesting from us, which was, to my memory, it was the login information essentially, and it might have been other things I'm not aware of, like packets and things. I'm not aware of the technical terms, but basically, they were asking us to provide that information to the FBI investigators. Taylor asked Gamut what they turned over, and he mentions database information. When you say two databases, do you mean the two genetic genealogy databases that allow law enforcement search? Yes, Gamut affirms. To my knowledge, these samples were searched in two genealogical databases that allow searching by law enforcement, GED Match and Family Tree DNA, I believe were the two that were searched, and we were asked to provide those credentials, that information, to the FBI. Gamut confirms that Othram provided what is called a, quote, preliminary report, end quote, which contained no notes or work product, and they were then told to, quote, terminate the testing, end quote. It should be noted that law enforcement agencies may be given access to CODIS, but not private DNA databases. Why was the decision made for the FBI to take this over and not let Othram finish? I don't know, Gamet says. I can't speak to that. And this is where Ann Taylor's line of questioning moves from the ridiculous to the sublime. She has already secured sworn testimony from lead detective Brett Payne that the FBI never told him they found Brian Kohberger's DNA on the sheath. She has put former lab director Nowlin on the record stating that Othram was a state-approved vendor. She has put Gamet on the record saying Othram obtained a profile from DNA found on the K-bar sheath and traced it to 4 brothers who were not named Kohberger. She has established that virtually everything Latah County prosecuting attorney Bill Thompson has said about his only physical evidence is false. Okay, Taylor asks, did you ever take a look at the 2 profiles, the FBI's SNP profile and Othram's SNP profile? Have you ever looked at those? Did we look at those, or did I look at those? Did you? I did not, no, Gamet says. Have you seen them? No. Would it surprise you to know the FBI profile was over twice as big as Othram's? Again, I have no knowledge of what the FBI did or didn't do, Gamet answers. I had no knowledge, yeah. One last thing, before Lorenz's butterfly fully becomes a storm. Taylor has just documented that Thompson's Brady disclosure included almost no documentation of Othram's work. It did not mention the DNA profile they generated, the interview of the unidentified brothers, or the December 10 interagency phone call, which seems not to have been recorded or documented in written reports. Any of the work that Othram did in getting the DNA sample all the way down to SNP profile, where are they? Taylor asks. Where is the documentation of that? Gamet responds. I do not have that documentation. That was not provided to us, to my knowledge. And I don't know everything that was provided back to the laboratory, potentially. But to my knowledge, we were not provided with that information. Would Othram have it? She asks. Potentially. I don't know. The work that they did to come up with a name to give you for further investigation, where are those documents? I don't know. Nor does anyone else, it seems. Ann Taylor's office never received additional information about how DNA found on the K-bar sheath was initially used to identify 4 brothers whose names have been lost to history. All testimony recorded and transcribed in 175 pages of property filed by clerks was sealed from public scrutiny by Judge Hippler right before he denied the defense's pleas to suppress. Chapter 14, Dark SUV, Loud Exhaust, 12 nanograms per milliliter. There is no way to properly analyze this case without addressing the issue of how the killer actually got to and escaped from the house. Based on widely available door camera video, we all know about the white 4-door sedan police have identified as an Elantra and tied to Brian Kohberger. We know from the same video that DoorDash driver Molly McMichael was there as well. She can be seen walking up and down Queen Road with a flashlight just minutes before the crimes. And based on police reports, we know she claims a light-colored sedan drove next to her as she was walking. As Detective Payne wrote in LCPA Supplemental 157, documenting his November 23 interview with McMichael, during the time McMichael was in the area of the King Road residence, the white Elantra can be seen via the 1112 King Road camera driving back and forth on Walenta Drive and then enter the King Road, Queen Road loop at approximately 0356 hours. The DoorDash driver said she first parked behind the house based on GPS and then got out and walked around front, trying to verify the address. McMichael said she started to walk down the road, which runs north-south immediately to the east of the residence. McMichael stated a tan sedan drove next to her while she was walking. For some reason, police did not trust her recollection. At that point, McMichael pulled into the front parking lot before she dropped the order off. The white Elantra pulled in behind McMichael's vehicle, a gray Subaru Forester, and then exited the King Road at approximately 0358 hours. McMichael did not mention seeing the white Elantra behind her at any time. Perhaps she did, but it appears that police did not believe her. Subsequent investigation of video footage and cellular data showed that the, quote, tan sedan, end quote, McMichael saw was likely a light-colored SUV which left the area. Those who view the 1112 video for themselves will see that an unidentified SUV did arrive at 3:46:07, but that is almost certainly McMichael arriving in her gray Forester. She can be seen walking with a flashlight at 3:51:42. time-stamping her presence in front of the house, and we can see from the video that no other vehicle drives down King Road until 3:53:38, when a light-colored sedan leaves via King Road toward Taylor. At 3:56:24, a white sedan enters the neighborhood and passes King to Queen out of sight, only to return at 3:58:19. McMichael's Subaru is seen leaving the area at 4:00:38, making it impossible that she saw an SUV. Why, one might ask, is this important? The single least debatable fact in this entire case is that a white four-door sedan traveled in and out of the neighborhood numerous times until 4:20:45, when it leaves at a high rate of speed and disappears southeast up Walenta. Bill Thompson made it a part of his evidentiary testimony at Koberger's change of plea hearing. At approximately 04:20 that morning, he said, defendant's car is seen on a surveillance camera for 1112 King Road, leaving the area at a high rate of speed. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. What no one has yet publicly discovered, however, is that there is another vehicle that presents compelling questions about who might have gone in and out of that house Sunday morning. Oddly enough, this mystery starts with Dylan Mortensen. She told police she saw a dark truck passing the house just after the crimes. In order to place this vehicle in context, we need to return to her November 17, 2022 interview with ISP Detective Vicky Gooch and MSP Detective Dustin Blaker. Though we have covered the written summary of this discussion, ISP Supplemental 3, the author has obtained the actual audio recording, which had not been released to the public at the time of this writing. This interview was conducted at Mortensen's residence in Boise with her lawyer, Robin McPherson, present via video feed from the Sullivan Law offices in Moscow. Can you think of anything else right now? Gooch asks at the 1:26:28 mark. No. Oh, so this is something else that I remember. Cars do come by a lot, but I remember looking out the window. I just remember, I think it was a black truck. I don't know for sure, but like that is normal for cars to go by, but like, I don't know if that could be something, just a car driving past our driveway. What time was that at? Gooch asks. That was right when I went down to see Bethany, so I don't know exactly when that was. Was it moving? Was it in movement? It was moving. It wasn't stopped at all. It was moving, and like people drive by our driveway, like around this side housing neighborhood a little bit. Like we hear cars go by all the time. That's not weird, but when you were making your way to Bethany's room, that's not it was when I got into Bethany's room. I don't know why I looked out the window, but I saw a car drive by, and I believe it was I shouldn't say I believe, because I don't know for sure, but I think it was a black truck. But I don't know for sure. It could have been it was dark, and I just thought it was a black truck. As luck would have it, one can actually document her statement via the 1112 door cam recording. At 4:23:49, a dark, full-size SUV passes in front of 1122 King Road with a distinctive audio signature caused by what appears to be very loud exhaust. Unlike the white sedan, this dark SUV turns right on Taylor Road instead of left on Walenta. We know this because of the, quote, dumpster video, which clearly shows it passing eastbound on Taylor at 4:25:17. Things start to get interesting, however, when the dark SUV returns to King Road at 4:28:49, as documented by the 1112 camera. Review of the dumpster video verifies it returning along Taylor Road, meaning it left the neighborhood just 5 minutes after the white Elantra, then returned about 4 minutes later. What really stands out, however, is a third set of images captured by widely known footage referred to as the Linda Lane video. This is the same camera police relied upon to document travel of the white Elantra before and after the crimes. Careful review of footage shows the boxy SUV parked nose in facing the camera. At 4:23:17, an unidentified subject carrying a backpack can be seen walking from the direction of 1122 King Road across the parking lot toward the truck. They appear to open the tailgate of the SUV, which triggers the interior dome light, then climb in through the driver's side door. Here is where things start to get weird. The SUV leaves its parking spot near Linda Lane, passes down Queen, turns right on Taylor, and returns by the same route approximately 4 minutes later. Instead of returning to its original parking space, however, it stops in front of 1122 King Road. We know this because the Linda Lane video shows that it did not return, and the distinctive sound of its exhaust is recorded by the door cam at 1112. Based on the recording and the SUV's distinctive exhaust, it seems clear that the vehicle stops in front of 1122, idles there for about 30 seconds, then shuts down its engine. You can hear a door close. Although the 1112 camera did not provide visual evidence, a witness did. According to police, a neighbor named Nick Makowicz contacted them November 18 to report hearing the loud engine Sunday morning around 4:30. ISP Detective Hugh Powell documented the call in ISP Supplemental 196, noting that Makowicz lived at 1106 King Road. Powell wrote, "After going to bed, he had been asleep for approximately an hour when he was awoken by a vehicle with loud exhaust speeding away down the street past his house." Makowicz said he did not actually see the vehicle, but a different neighbor did. On February 16, 2023, Detective Payne interviewed a man named Jeffrey Manning. He wrote in LCPA Supplemental 147. Manning started by stating he lived at 1868 Conestoga Drive in Moscow and had called in a tip early on in the investigation about seeing a vehicle drive by his house at approximately 0425 to 0430 on the morning of November 13th, 2022. Manning told me he was out in front of his house at the time, placing items into his recycling and trash bins. Manning told Payne he could not describe the vehicle other than its headlights, teardrop-shaped taillights, and unusually loud exhaust. He believed it was an SUV. Payne reported, "Manning also told me the vehicle was going faster than usual, but did not seem to be driving erratically or dangerously. Manning told me it was quite unusual for anyone to be driving in the area at that time, and said he had not seen many cars driving at that time since the morning of November 13th, 2022. It seems that police were not the only ones aware of this SUV. Manning stated he was contacted by someone from the Kootenai County Public Defender's Office who asked him about the dark SUV he caught on security camera, Payne wrote, adding that Manning did not have any surveillance footage to give them. Perhaps not, but fortunately, the camera at Linda Lane did. At 6:23 a.m., the mysterious SUV returned to its original parking spot to the east of 1122 King Road near Linda Lane. It appears that the same person who entered the vehicle at 4:23 exits the driver's side door with a backpack and walks west toward 1122 King Road. For the record, this is the dark SUV with the same distinctive exhaust that is documented leaving and returning approximately 4 minutes after the crimes by 3 witnesses and 3 separate cameras. This is the vehicle that left Linda Lane only to park for 2 hours in front of the crime scene and return to its original parking spot 2 hours later. The camera at 1112 King Road provides no indication that the vehicle started or moved during that time. For those wondering, what might have happened inside the house in the 8 hours after the crimes, who might have cleaned up the common areas of the second floor, and where all those blood-soaked materials might have gone, the dark SUV prompts compelling discussion. To this day, no one has identified the distinctive-looking vehicle with the easily identifiable exhaust. Why did someone walk out to it at 4:30 in the morning, put something in the back, and drive away, only to return 4 minutes later and park in front of the house, only to repark in its original spot 2 hours later? As with so many unanswered questions, now that Kohberger is admitted to the crimes, no one seems to care. Retired FBI Special Agent Christopher Holland is a forensic criminologist engaged by the defense to evaluate certain aspects of the prosecution's case. Based on thousands of Brady disclosure files, he composed a behavioral evidence analysis, quote, seeking to establish and understand the role of victim psychodynamics and their contextual vulnerability with relation to the crimes, end quote. Relevant portions of his 38-page report are here excerpted verbatim. Idaho v. Brian C. Kohberger, case number CR 0124316665, Holland Felony Analysis, LLC. Medico-legal findings. Victim autopsies were completed on 11/16/2022 by Veena D. Singh, MD, MPH, Chief Medical Examiner for Spokane County, Washington. The following are extracts from the autopsy reports. Note, There was no evidence that any of the victims were sexually assaulted. Kaylee Goncalves. Investigative reports indicate that this 21-year-old female was found deceased in her shared home at 1122 King Road, Moscow, Idaho. Post-mortem examination showed a well-developed adult female with stab and incised wounds of the scalp, face, and neck, 24 plus, stab and incised wounds of the chest, 11, and stab and incised wounds of the upper extremities, 3. Associated injuries included punctures of the outer table of the skull, injuries to the teeth and tongue, perforations of the subclavian artery and vein, and hemorrhage into the chest cavities. Blunt force injuries included scalp laceration, bleeding around the brain, and nasal fracture, as well as scrapes on the nose and cheeks, bruising around the eyes, and patterned bruises extending across the lower face. Petechial hemorrhages were present in the eyes and mouth. There was no evidence of natural disease that would have caused or contributed to death. Note, postmortem toxicology testing showed a blood alcohol concentration of 0.107 grams per 100 milliliters. The cause of death is multiple sharp force injuries. Blunt force injuries of the head and asphyxia injuries were listed as significant contributors to death. Madison Mogan. Investigative reports indicate that this 21-year-old female was found deceased in her shared home at 1122 King Road, Moscow, Idaho. Postmortem examination showed a well-developed adult female with stab and incised wounds of the scalp, face, and neck, 13, stab wounds of the chest, 5, and incised wounds of the upper extremities, 10. Associated injuries included wounds of the lung and liver, as well as perforations of the subclavian vein, subclavian artery, and blood vessels of the chest wall. There was no evidence of natural disease that would have caused or contributed to death. Note, postmortem toxicology testing showed a blood alcohol concentration of 0.282 grams per 100 milliliters. The cause of death is multiple sharp force injuries. Xander Canodal. Investigative reports indicate that this 20-year-old female was found deceased in her shared home at 1122 King Road, Moscow, Idaho. Postmortem examination showed a well-developed adult female with stab and incised wounds of the scalp, face, and neck, 23. Stab wounds of the chest, 7. And abdomen, 4. Incised and puncture wounds of the back, 3. Incised wounds of the upper extremities, 25. And incised wounds of the lower extremities, 5. Associated injuries included punctures of the outer table of the skull, perforations of the jugular vein, heart, lung, and pulmonary blood vessels, hemorrhage into the chest cavities, and wounds exposing the bones of the hand. Additional injuries included scrapes and bruises on the face, torso, and extremities. There was no evidence of natural disease that would have caused or contributed to death. Note, postmortem toxicology testing showed a blood alcohol concentration of 0.229 grams per 100 milliliters and an amphetamine level of 12 nanograms per milliliter. The cause of death is multiple sharp force injuries. Ethan Chapin. Investigative reports indicate that this 20-year-old male was found deceased in a shared home at 1122 King Road, Moscow, Idaho. Postmortem examination showed a well-developed adult male with stab and incised wounds of the scalp, face, and neck, 4, a stab wound of the upper chest, 1, incised wounds of the upper extremities, 6, and stab and incised wounds of the lower extremities, 6. Associated injuries included perforations of the jugular vein, subclavian vein, and subclavian artery. There was no evidence of natural disease that would have caused or contributed to death. Note, postmortem toxicology testing showed a blood alcohol concentration of 0.122 grams per 100 milliliters and an amphetamine level of 260 nanograms per milliliter. The cause of death is multiple sharp force injuries. Victimology. Kaylee Goncalves was a senior at the University of Idaho, 21 years of age. She was born in Coeur d'Alene, Idaho, and graduated from Lake City High School in 2019. She enrolled in the University of Idaho at Moscow, majoring in general studies at the School of Arts, Letters, and Social Sciences. She reportedly intended to be a school teacher. She had completed her studies and moved back to Coeur d'Alene, living with her parents. She returned to Moscow that weekend to attend the homecoming football game and begin preparations for her move to Austin, Texas, where she planned to share an apartment with a female friend, Jordan, and an unidentified male she met online. The week prior to her murder, she purchased a Range Rover in conjunction with the anticipated move. Kaylee is described as unproblematic and peaceful and, quote, having it together, end quote. Kaylee was active on social media, and her posts garnered a significant number of responses, though there is no indication she sought to be a social influencer. Kaylee was best friends with Madison Mogen, whom she had known since they were in sixth grade. She had a boyfriend, Jack DeCour, whom she had known since high school. He was also in attendance at the University of Idaho. At the university, they shared ownership of a dog named Murphy. Their relationship had ended in the weeks preceding the murder. She reportedly had a relationship with a fraternity member at Delta Tau Delta with whom she would occasionally, quote, hook up, end quote. In the weeks prior to the murders, Kaylee had reported to friends that she thought she was being stalked. During the evening and early morning hours of November 12, 13, 2022, Goncalves consumed drugs, including Adderall and alcohol, which would inhibit the ability to think and react. She was in a residence with other individuals who had been drinking heavily, creating the potential for harm to occur. Persons who did not live at the residence had access to the combination to the cipher lock on the front door, creating a risk of an intruder. At the time of her death, Goncalves' blood alcohol content was 0.107 grams per 100 milliliters. Based on potentially harmful environmental elements and behavioral factors impacting Goncalves' day-to-day life, she is assessed a medium lifestyle exposure. Based on actual vulnerability to harm, she is assessed a medium situational exposure. Madison Mogen was a popular member of Pi Beta Phi sorority and the Big of Bethany Funk, who also lived at 1122 King Road and survived the attacks. Mogen moved into the King Road residence in 2021. Friends considered Mogen a strong and thoughtful person. She worked part-time at the Mad Greek, a Moscow restaurant, where Xana Kernodle also worked. She was a marketing major and had begun using those skills in a media campaign for the restaurant and interned with an insurance company. During an interview with police, one friend described first meeting Mogen when she was walking around, quote, without any clothes, end quote. The friend said she got her clothes and walked Mogen back to Pi Beta Phi, where she lived at the time. Mogen regularly posted photos of an influencer nature with her friends and sorority sisters at various college events, as well as posts with her boyfriend, Jake Schrager. One of her posts solicited a response from Peach Perfect Scouts, who appeared to be looking for online influencers and brand ambassador recruiters. Mogen had an Instagram account with the username Maddie Mogen and display name Madison May Mogen. The account profile stated, quote, backup, OnlyFans, DM me for any information. My 18 plus content here, OnlyFans, Maddie Mogen, end of quote. Madison Mogen consumed alcohol and used drugs recreationally. Any use of illegal drugs requires interaction with someone who is potentially dangerous. Mogen had an account on OnlyFans, which could potentially draw attention to her. The incident of another student finding her without clothes suggests she was inebriated in public or high on drugs, either of which would increase her lifestyle exposure. Mogen's postmortem toxicology showed a blood alcohol content of 0.282 grams per 100 milliliters. This is sufficient to cause impairment of speech and movement, and therefore could have affected her ability to react when she was attacked. At the time of her death, she was living in her own residence. Other persons were present who had been drinking heavily, creating the potential for harm to occur. Persons who did not live there had access to the combination to the cipher lock on the first floor, creating a risk of an intruder. Based on potentially harmful environmental elements and behavioral factors impacting Mogen's day-to-day life, she's assessed a moderate lifestyle exposure. Based on actual vulnerability to harm, she is assessed a moderate situational exposure. Xana Kernodle was born in Sandpoint, Idaho, and graduated from Post Falls High School. She was a state champion gymnast. Her parents are divorced. Her mother is in prison on drug-related charges. She enrolled at the University of Idaho in May 2022 as a marketing major. She enjoyed volleyball. She was a member of Pi Beta Phi, as was victim Madison Mogen and witness Dylan Mortensen. However, she had to drop from the sorority due to inability to pay the $1,000 membership fees. She was a server at the Mad Greek, where Mogen worked. She was very popular among her peers with a cheerful, outgoing personality. She had been dating victim Ethan Chapin for about 6 months. Xana Kernodle's postmortem toxicology testing showed a blood alcohol concentration of 0.229 grams per milliliter and an amphetamine level of 12 nanograms per milliliter. This is sufficient to cause impairment of speech and movement, and therefore could have affected her ability to react when she was attacked. At the time of her death, She was sleeping in her own residence where other persons had been drinking. Some had been using drugs. Based on potentially harmful environmental elements and behavioral factors impacting Kernodle's day-to-day life, she is assessed a moderate lifestyle exposure. Based on actual vulnerability to harm, she's assessed a moderate situational exposure. Ethan Chapin was the oldest of triplets, one brother, one sister, born in Conway, Washington, and graduated from Mount Vernon High School, Skagit County, Washington. He was in his sophomore year at the University of Idaho, 20 years of age when he was murdered. He was an avid swimmer and surfer, 6'4" in height and 228 pounds. Chapin was a member of the Sigma Chi fraternity, but could not live in the residence due to his poor grades. He had been dating Xana Kernodle for about 6 months. His Facebook page had an open list of 140 friends, with few posts from 2021. He was athletic, calm by nature. At the time of death, Chapin was at the residence of Xana Kernodle, where other persons had been drinking heavily and some had been using drugs, creating the potential for harm to occur. Persons who did not live at the residence had access to the combination to the cipher lock on the first floor, creating a risk of an intruder. His postmortem toxicology testing showed a blood alcohol concentration of 0.122 grams per 100 milliliters and an amphetamine level of 260 nanograms per milliliter, sufficient to cause impairment of speech and movement. Based on potentially harmful environmental elements and behavioral factors impacting Chapin's day-to-day life, he is assessed a moderate lifestyle exposure. Based on actual vulnerability to harm, he is assessed a moderate situational exposure. Possible evidence of 2 offenders. 1. Kaylee Goncalves was found dead in a full-size bed directly adjacent to Madison Mogen. Autopsy reports show that she suffered 3 defensive wounds to upper extremities, indicating she was surprised and overwhelmed by her attacker. Cast-off blood on the walls of the bedroom where she died indicates her attacker climbed onto the bed and slashed at her from right to left. Wounds she sustained to the top of her skull are consistent with an assailant mounting her upper body and striking downward. While choking, beating, and stabbing Goncalves, it would have been extremely difficult for a single offender to simultaneously control Mogen and prevent her from fleeing the open side of the bed. The mechanism, brutality, and chronology of these 2 murders strongly indicate the presence of 2 or more offenders. 2. Ethan Chapin's undiluted blood was found at the top of the stairway leading from the 2nd floor to the 1st. According to the state's own experts, there is no evidence that Ethan Chapin left his bed after being attacked. According to statements by surviving witness Dylan Mortensen, the man in the black balaclava made his escape, moving directly from Xana Kernodle's bedroom to the sliding door in the kitchen and never went near the stairway. If Mortensen is correct, the man she saw could not have transferred blood to that location. The presence of Chapin's blood on the stairwell necessitates transfer from a second offender. 3. Xana Kernodle sustained 64 wounds, while Ethan sustained 11 wounds. Wounds to Chapin's lower extremities are evidence that he awoke after being attacked and reacted to the assault by pulling his legs up into a defensive posture. The absence of blood on white socks he was wearing at the time of death proves that he was attacked in bed and never rose to assist Xana Kernodle as she was fighting for her life on the floor beside him. Based on the nature and extent of wounds inflicted upon Chapin, it is impossible to believe that he slept through the attack on Kernodle, and it is illogical that Kernodle stood in her bedroom and waited for the offender to kill Chapin before killing her. The only possible explanation is that the 2 were attacked and killed simultaneously by more than one assailant. 4. When let out of the house at 02:30 hours, Murphy, the dog, ran away, as evidenced by Bethany Funk's statements to police. Braden Paulo, residing at 1127 King Road, stated that Murphy was the only dog in the neighborhood, and Paulo awoke sometime after 0400 to the sound of Murphy barking. The barking continued until almost 0500, when it stopped abruptly as if he had been let inside. As of 0430, Funk and Mortensen were the only persons known to be in the residence, and according to statements by both women, they never left Funk's first floor bedroom until approximately 1154. The only explanation is that a second offender was still in the residence at 0500 and that the offender opened a door, allowing Murphy back into the house. 5. The floor in Xana Kernodle's room was covered with blood, which should have resulted in bloody footprints in the hallway outside. The lack of footprints in the hallway indicates that the floor was cleaned sometime between 0415, when the murders occurred, and noon, when police arrived. Police reports document cast-off blood in the common areas of the second floor, which had been, quote, diluted with an unknown substance, end quote, indicating efforts to clean up after the murders. In statements to police, Mortensen said she observed a masked man in black clothes walking from the direction of Xana Kernodle's bedroom through the kitchen as he exited the house. If this offender left immediately after killing Chapin and Kernodle, a second offender had to have stayed to alter the scene. 6. At 10:00, the front door of the residence was observed open by a witness walking his dog. Due to its location at the bottom of the stairs, Mortensen would have noticed the door being open when she relocated to Funk's bedroom at 04:30. Had the door stayed open all night, the first floor would have been cold, but neither Funk nor Mortensen made that observation. Someone else in the house must have opened or closed the door. Method of attack. Kaylee Goncalves was killed in a blitz attack. That is, the offender suddenly and viciously attacked her in her sleep with overwhelming force. Goncalves' cast-off blood was found on the ceiling above the bed and on the walls. This indicates great force used in the attack. Goncalves received 38 sharp-edged wounds, with only 3 being defensive wounds, reflecting complete surprise and an inability to fight back. She sustained blunt force trauma to her face, resulting in fractures, and she was strangled to the point of petechia, which requires a significant amount of time to induce. Madison Mogen was also assaulted in a blitz attack in which she sustained 28 sharp-edged wounds, with 10 being defensive wounds to upper extremities. Cast-off blood on the far walls of the room and the ceiling indicated that great force was used in the attack. Xana Kernodle suffered a surprise attack where neither the victim nor the offender was aware of the other's presence until just before the encounter. Ethan Chapin was murdered in a blitz attack in which the offenders suddenly and viciously overwhelmed him with sharp-edged weapons. He received 11 significant wounds, including the fatal blow to his throat. Evidence of planning. These attacks were not spontaneous. The offenders had to select, surveil, and prepare for the attacks. The planning was not extensive, however, based on errors made in altering the crime scene and handling of the dog. Evidence indicates that the offenders were either unaware Ethan and Xana were home or anticipated they were asleep and did not expect to encounter them when they moved to the 3rd floor. At least one offender was dressed in black and wearing a balaclava to conceal their identity. The offenders had knowledge of the house. Offender traits and characteristics. Signature behaviors are acts committed by an offender that exceed what would normally be expected during the crime. These excessive actions suggest a psychological or emotional need that is unique to the assailant at the time of the offense. Both Goncalves and Mogen received identical post-mortem wounds to the throat and left shoulder. These post-mortem wounds represent a compulsion by the offenders to disfigure the victims. They indicate an excessively violent behavior associated with rage. Based on these characteristics, we can conclude the following. Kaylee Goncalves was the primary target of these attacks. She had completed her coursework and moved from 1122 King Road to her parents' home in Coeur d'Alene, Idaho. She returned to U of I that weekend for the express purpose of attending the homecoming football game and selling furniture she had in her room in preparation for her move to Austin, Texas. The weekend of 11/12 to 13/2022 would have presented the killers with one last opportunity to kill Kaylee Goncalves. They bypassed persons on the 2nd floor and went directly to the 3rd floor, seeking Goncalves. Goncalves sustained strangulation and blunt force trauma, resulting in facial fractures and 38 wounds inflicted by sharp-edged weapons. Goncalves was strangled, as evidenced by the presence of petechial hemorrhage. There is no evidence of ligature use, indicating she was strangled by hand, the most personal of all homicidal methods. Injuries inflicted on Goncalves represent overkill in excess of what was necessary to cause her death. One or both offenders had a deep personal anger against Goncalves. The attack was directed primarily at her face, which was severely disfigured in an effort to destroy her identity. This indicates the offender had a personal and deeply hateful relationship with his intended target. Madison Mogen sustained 28 injuries from a sharp-edged weapon and was an intended, though secondary, target. The killer's aggression toward Mogen would be described as retaliatory anger, but to a lesser extent than Goncalves, as she sustained far fewer injuries. The act of staging Goncalves' head on Mogen's shoulder, the identical nature of wounds inflicted post-mortem on both victims, and the fact that the killers tucked them in beneath a comforter indicate they were aware of and resented the close relationship between Goncalves and Mogen. As Mogan's injuries were less severe than Goncalves, the anger toward Mogan was possibly due to her relationship with or a trait she shared with Goncalves, and not specifically because of something Mogan had done. Xander Knodel was murdered to protect the identity of the offenders. Had she been sleeping in her bedroom, it is unlikely she would have been killed. Ethan Chapin was murdered to protect the identity of the offenders. Had he not awakened, it is unlikely he would have been killed. If the first two pillars of Bill Thompson's case are DNA and the white sedan, the third and final pillar is the FBI cast analysis tying Brian Kohberger's cell phone to the scene. To be precise, no law enforcement document ever places Kohberger's phone anywhere near the scene of the crime between the hours of 2:47 a.m. and 4:48 a.m. If the state is correct in asserting that all four murders occurred in the moments before surveillance cameras at 1112 King Road recorded what sounds like a woman, Xana, screaming, and a white sedan speeding away, it could not have tied it to Kohberger's phone because it was off. What we know about the prosecution's evidence, in lieu of a trial, begins with what the Latah County prosecuting attorney told us at the change of plea hearing. At about 04:48 that morning, the defendant's phone comes back on, Thompson states, and the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. Using the term likely might seem conspicuously a feat in a death penalty prosecution, but those were his words. From there, the defendant's phone activity tracks a heading back north towards Pullman, Washington, where the defendant lived. About 0526, starting approximately 0526, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 0530 in the morning. According to reports the FBI cast team prepared for trial, the words, quote, towards Pullman, end quote, mean absolutely nothing. Cell tower analysis shows that it was impossible to track Kohberger's phone to less than a 10-mile radius. Yes, he could have been traveling toward Pullman or anywhere else north of Nevada, but there's more. Based on Brett Payne's December 20 arrest warrant affidavit, we know all about what prosecutors believed at the time. We'll recall that police referred to Kohberger's AT&T cell by the last four digits in his number. A query of the 8458 phone in these returns did not show the 8458 phone utilizing cell tower resources in close proximity to the King Road residence between 3 a.m. and 5 a.m., Payne wrote. While many would conclude that this was due to the phone not being anywhere near that location, recall that Payne extrapolated, based on his experience, that, quote, individuals can either leave their cellular telephone at a different location before committing a crime or turn their cellular telephone off prior to going to a location to commit a crime. This is done by subjects in an effort to avoid alerting law enforcement that a cellular device associated with them was in a particular area where a crime is committed. Based on cast analysis and data obtained from a December 23, 2022 police report, it was determined that Kohberger's cell, quote, utilized cellular resources that provide coverage to Idaho State Highway 95, south to Moscow, Idaho, near Blaine, Idaho, north of Genesee. They claimed that between 4:50 a.m. and 5:26 a.m., his phone traveled south on 95 to Genesee, then west toward Uniontown, then north back into Pullman. At approximately 5:30 a.m., the 8458 phone is utilizing resources that provide coverage to Pullman, Washington, Payne wrote, consistent with the phone traveling back to the Kohberger residence. Though this all makes sense on its surface, Payne did not mention the FBI's specific analysis or the fact that the only way to verify cell tower pings was to match them with what they claimed to be their suspect's white Hyundai Elantra. Bizarrely, Payne noted in his affidavit that FBI analysis did show Kohberger's phone connecting to a cell phone tower providing service to Moscow on November 14, 2022, but for some reason did not believe, quote, the 8458 phone was in Moscow on that date, end quote. No explanation was offered regarding this obviously troublesome fact. On July 8, 2024, the FBI provided Bill Thompson's office with a colorful and animated 31-page historical mobile device location analysis completed by Special Agent Nicholas Balance. Page 1 of this Cellular Analysis Survey Team, or CAST, report states that the MPD requested assistance with 3, quote, target cell phones, end quote, which need not be printed here, though they are obviously tied to the murders. One, of course, is Koberger's, and for reasons not yet explained, the other two belong to victims. The report offers basic information about methodology, which amounts to matching a phone with the tower it pings, and notes that locations are denoted in latitude and longitude using, quote, mapping software, end quote, that is not further described. Page 2 of the report shows a map graphic depicting tower locations in the area surrounding Moscow, photographic depictions of sample towers, including a simulated evergreen tree, a flagpole, and a cactus. Page 9 of the report lists, quote, locations of interest, end quote, as the crime scene at 1122 King Road and Koberger's apartment at 1630 Northeast Valley Road, apartment G 201 in Pullman. The following page maps 2 AT&T network towers in Moscow, 7 in Pullman, and 2 along Route 270, the primary route connecting the two towns. The report lists Koberger's phone information with a 509 prefix, a billing address in Pennsylvania, and an activation date of June 23rd. From there, the cast report uses maps, legends, and graphic representations to track Koberger's phone based on where and when it pinged on the closest adjacent towers. Although Bill Thompson made bold claims about what these analyses show, a thorough review of the cast report leads to very different conclusions. Since this document is animated with highlights, diagrams, and graphics full of information, it appears obvious that it was built for courtroom presentation, specifically to bolster expert testimony. The 8458 phone had no network interactions on November 13, 2022, between 2:54:45 a.m. and 4:48:40, page 14 proclaims. This we already knew. After 4:48, the cast report shows tower connection south of Moscow, as the prosecution has alleged. Based on a legend at the bottom of the page graphic, it appears that Koberger's car could have been as far away as 25 miles from the crime scene at the time. Between 5:20 and 5:27 a.m., it appeared to have pinged towers south and east of Koberger's apartment in Pullman. Between 6:13 a.m. and 8:03 a.m., he placed 3 calls to 2 different family members, received a 4th call from one of them, and received 1 text. Notably, one of the calls at 6:17:15 a.m. lasted more than 36 minutes, while a second at 8:03:10 a.m. lasted almost 55. All 5 of the communications pinged a tower within 2,000 feet, according to the report. At 9 a.m. and 9:03 a.m., Koberger's phone pinged a tower south of his residence from 2 different directions, implying travel, and 9 minutes later interacted with the tower in Moscow. From there, the cast charts show Koberger's phone pinging towers over a broad stretch of Latah and adjoining counties as far as Sweetwater, which is almost 50 miles south. While one could certainly see how Bill Thompson's office used these charts to link Koberger to the crime scenes, it is just as easy to use the same graphs to argue that microwave geometry makes it impossible to pinpoint locations within a range of less than 10 miles. For reasons that are not immediately obvious, the cast presentation tracks certain cell communications for Maddie Mogan. A chart on page 27 shows her phone receiving incoming calls at 4:19:58, 4:21:55, and 4:28:42. Clearly, these document calls Dylan Mortensen and Bethany Funk say they made shortly after the murders, but there is no information in the report to indicate origin, type of transmission, or length of connection. The last 2 pages of the cast report document Koberger's phone pinging a tower, quote, providing coverage to within 100 meters, end quote, of 1122 King Road 23 times between July 9, 2022 and November 7, 2022. The report notes that all 23 connections occurred between 10 p.m. and 4 a.m., implying perhaps that Koberger cased the house late at night. What they do not state is that none of the residents had even moved into the house at that point, and that while the tower in question could have tied a user to within 100 meters of the crime scene, it could not, in fact, prove that they were closer than 10 miles. As for the science and methodology behind the cell tower analysis, Ann Taylor had hired an expert named Cy Ray. According to an April 2024 defense filing, the former police officer and founder of ZX Corporation planned to refute FBI cast analysis based on missing information and incomplete data. Koberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho, on November 13, 2022, Taylor's office wrote, seeking discovery of additional information from police. Brian Koberger's mobile device did not travel east of the Moscow-Pullman Highway in the early morning hours of November 13th, and thus could not be the vehicle captured on video along the Moscow-Pullman Highway near Floyd's cannabis shop. Cy Ray actually testified to misgivings during a pretrial hearing. Because of piecemealing of the data, because of the missing data, because of the data I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in benefit of the defense right now, he said. There are other reports that are missing that I can't tell you are benefiting of Mr. Koberger or the state. Although Ray has remained outspoken about what he perceives to be flaws in the FBI's methodology and conclusions, there will be no trial. He will not get the chance. Chapter 15, Drunk or Not, Death Row, The New Normal. No one knows what really happened inside that house early Sunday morning, but we all know it did not. We know the killer did not stop at Dylan Mortenson's room on his way upstairs toward his intended targets. We know the assassin did not by himself asphyxiate, beat, stab, and hack away at Kaylee Goncalves while Maddie Mogan lay quietly in bed beside her without fighting back or running away. We know that a complete stranger would not take the time to slice each of their throats twice post-mortem before suggestively posing their bodies in an assault that Bill Thompson himself said was not sexual in nature. We know that Dylan Mortenson did not apparently hear the extreme violence of the attacks, though her bed was directly beneath Maddie's in a house where she told police, quote, "You can hear everything," end quote. We know, despite Brian Koberger's admissions of guilt, the police have not produced a shred of evidence linking him to any of the victims or the two survivors. There is no indication in the terabytes of investigation that he ever visited or stepped inside the house. In terms of means, motive, and modus operandi, we know the killer premeditated his crimes, wearing black clothing and a balaclava to the scene, though we don't know why. We know he left blood transfers on the walls and flat surfaces in the stairwell, but not on the floors. We know he did not interact with Murphy because the dog was lying on Kaylee's bed when police arrived with no signs of injury and not a drop of blood on his fur. We know from Bethany, neighbors, and ring cam audio that Murphy was barking outside the house 45 minutes after the murders, but we do not know how he got back inside. Moving downstairs, we know that the killer did not stop at Dylan Mortenson's room on his way out. We know the killer attacked Xana in or near the kitchen, chasing her across the living room as she screamed so loudly it was picked up on a ring camera down the street. But we do not know why no one heard her in the house. We know from lab reports that the killer splashed Maddie's and Kaylee's blood on the living room walls, but we do not know how every droplet was found to have been, quote, diluted with an unknown substance, end quote. We know blood was found on the floors of both murder scene bedrooms, but we don't have a clue how the killer walked through the house without tracking anything around on his shoes. We know police found a beer pong table blocking the path of what would have been Xana's frantic escape toward Ethan, but we cannot explain its apparent lack of displacement. We know what the table looked like in cell phone pics Lakeland McComas took around 1:15 a.m., but not why things changed by the time Nunez arrived. We know they found Xana's blood spatter on one side of the table and Maddie's and Kaylee's on the knee wall at the far end, but we have no clue what physics police used to make sense of the trajectories. We know police found Hunter Johnson's steak knife near bloodstains within plain sight of Xana's body, but not why they dismissed it. We know Bethany told police she woke up to a loud bang and the sound of the beer pong table moving and cups falling. Moving down the hall toward Ethan's mutilated body, we know police found it covered with a blanket, but not why or when or how. We know that Dylan Mortenson told police she saw Xana's body on the floor moments after coming face to face with a man clad in black, wearing a mask, but not why she assumed her housemate was sleeping. She said she could see the top of Xana's head, though her head was pointing the other way, and that Xana was wearing a hoodie and underwear, but we don't know how she missed the giant pool of blood. Moving down to the first floor, we know detectives found Ethan's undiluted blood above the railing, but we have no idea how it got there. We know Dylan went down to Bethany's room, where the two women waited 8 hours before calling 911, but not why they called Emily and her boyfriend Hunter first. We know the front door was closed when Hunter arrived, but not why a witness swore it was open between 9 o'clock and 11 o'clock that morning while he walked his dog. We know that both women claimed they went immediately to sleep after all the ruckus, but not why records show they were up texting and using social media. We know they claimed they did not leave their room, quote, even to go to the bathroom, end quote, but not why Dylan's Apple Watch showed physical movement at 5 o'clock that morning, the exact time Murphy stopped barking. We know police found the downstairs bathroom scoured and completely empty of what one might expect to find in college housing, but not why they disregarded that as normal. We know they found a blood-soaked green jacket in the empty first-floor bedroom and that it tested positive for DNA mixtures that could not be, quote, deconflicted, end quote, except for one, which was Dylan's. We know they found a broken woman's bracelet on the floor of that same room, and the photographs suggest the bracelet was stained with blood, but there is no record stating why it was ignored. While on the subject of suspicious oversights, we know Spokane County Medical Examiner Dr. Veena Singh found, quote, trace evidence, end quote, in Ethan Chapin's hand that later turned out to be human hair. We do not know why it was tested for type and color, but not for DNA. We know the notorious K-Bar knife sheath was found either on the bed or on the floor, but not why. Nobody seemed to care. We know about potentially devastating issues with chain of custody and about the state firing Othram Laboratories seemingly at the same time they tied sheath DNA to 4 brothers, quote, whose name was not Koberger, end quote. We know about the sample being twice as large when it arrived at the FBI lab in Quantico, though at 0.168 nanograms per microliter, it was submitted to CODIS but deemed too small to be tested for YSTR. We know Ann Taylor's office went to great lengths trying to determine how the knife sheath DNA was tested and by whom, but not why none of the evidence was suppressed. Finally, we know that Brian Christopher Koberger admitted to being responsible for the crimes behind every one of these questions, but not why he chose to keep them secret. We know he pled guilty to 1 count of burglary and 4 counts of premeditated murder, but not how he committed the crimes, or most important, why. Perhaps none of this matters, because justice is blind, and according to the state of Idaho, justice has been served. Using the language of lawyers and courts, affiants have presented probable cause and affidavits based on evidence gathered in accordance with rules of criminal procedure. Warrants have produced vast tranches of information that would not have seemed imaginable just a decade ago. Digital records most people would not imagine government could so easily gather. Forensic experts have swabbed and processed crime scenes gathering biological traces so small they are measured in nanograms and cells. Gone are the days of fingerprint examination replaced by DNA analysis, a whole new language of forensic science full of terms like short tandem repeats, single nucleotide polymorphisms, and investigative genetic genealogy. Even with the change of plea, properly certified and duly appointed attorneys have carried out their responsibilities, arguing via Frank's hearings and motions in limine which evidence is exculpatory, admissible, and unfairly prejudicial. The judge, in this case Hippler, has exercised years of experience applying constitutional guarantees and case law precedent, using jurisprudence to weigh the best interests of an ordered society against those of the accused. Brian C. Koberger is doing life without the possibility of parole for heinous crimes he admitted to committing. But is it not reasonable to look at the facts of this case and wonder if justice has been served? In this era of crowdsourced inquiry, is it not our obligation to point out gaping holes in the prosecution's narrative and, in lieu of a trial, look deeper? If so, it seems easy to imagine how the whole thing might have played out at the Ada County Courthouse. Criminal trials always begin with opening statements, with the prosecution going first because they bear the burden of proof. In this case, Latah County prosecuting attorney Bill Thompson would have approached the jury detailing the gruesome nature of the murders, the legal elements of the crimes, the facts of the case, based on what the evidence would show. On behalf of the state of Idaho, he would express confidence that Brian C. Koberger was the only person responsible. We already know the basics of his presentation because he made it at the change of plea hearing. The state submits that the evidence would show that on November 13, 2022, Mr. Koberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice and forethought, Matty Mogan, Kaylee Goncalves, Ethan Chapin, and Xander Kernodle. Thank you. When he finished, Ann Taylor would have stood and offered firm but heartfelt confidence that fair and impartial consideration of the facts would prove her client innocent of all charges. She would have reminded the jury that the state's burden is proof beyond a reasonable doubt. She would have done her best to sound resolute, measuring her tone with conviction and compassion while trying to keep jurors from staring at her sometimes disturbingly awkward client. When she was done, Judge Hippler would have told Mr. Thompson to proceed, and the prosecution would have begun building its case by calling its first witness. We do not know who that would have been exactly, but based on what we heard in July, the state of Idaho's three-pronged narrative comes down to the K-bar knife sheath, video imagery of a white sedan, and cell tower analysis performed by the FBI. Due to the complex science involved in all three types of evidence, they would have called everyone from MPD officers like Nunez and Payne to ISP detectives like Maury and Gooch. They would have summoned FBI agents from Pennsylvania, Salt Lake City, headquarters, the Operational Technology Division, the Cellular Analysis Survey Team, the Critical Incident Response Group's Behavioral Analysis Unit in Quantico, and various other offices. Experts like Paulette Sutton would have been called to the stand, bolstering her findings with statistics and math. And though we know most of the players at this point, trials can be as theatrical as they are strategic. At some point, non-technical experts would have been called to the stand to lay out context, timeline, and foundation. Hunter Johnson would have been prominent among them, testifying to how and when he found the bodies. And Taylor would likely have cross-examined recollections about whether he touched the bodies, who went upstairs with him, where he found and left the knife. Both sides would have called friends and Greek life associates to the stand, looking to establish who might or might not have come into contact with the defendant. It is possible that Bill Thompson would have summoned Molly McMichael to the stand, establishing when she dropped food at the door. It is just as possible that Ann Taylor would have called her to introduce exculpatory statements she made regarding the driver of the tan sedan who looked nothing like the defendant. Perhaps Lakeland McComas would have testified about what she remembered as one of the last people in the house prior to the murders, or Emily Allant, who was one of the first to return. It is possible that the prosecution would have called Bethany Funk. As one of two survivors, she could testify to what she heard or observed during the commission of the crimes. The prosecution might have used her to establish events leading up to the murders, like where she last saw Kaylee upstairs, when she and Maddie took Murphy outside, what time she went to bed. It is just as possible that Thompson would not have called her due to significant issues with her statements about the 8 hours between Dylan running down to her room and the call to 911. It is difficult to believe that the prosecution would not have called Dylan Mortensen, despite her role as the only eyewitness. Based on her 4 statements, Dylan's testimony would have been cannon fodder for the defense. No matter how important her eyewitness testimony would have been in identifying Koberger's bushy eyebrows, I believe that little of what Dylan Mortensen has ever told police would have stood up at trial. In 4 separate interviews, conducted between noon the day of the crimes and 1:54 p.m. on December 20, she made what seemed to me to be innumerable contradictory statements about what she saw and heard, including who she heard running down the stairs, who was crying in the bathroom, and basic information about the man she saw leaving the house. No matter what Bill Thompson, online sleuths, and media opine about the veracity of her claims, no one can truly comment until they hear her actual words. The 2-hour and 7-minute audio recording of her interview with Gooch and Blaker, at least to me, sounds appalling. I don't know if my mind's like making up stuff like at that moment when everything was happening. She states with regard to Kaylee Goncalves running down the stairs with Murphy. I don't know how much I make stuff up so that I can remember, I just don't know. It just doesn't make sense to me, and I don't know how to fully explain it, I guess. Though not mentioned in Gooch's ISP summary, every single statement Mortensen made about what she saw, heard, felt, or did between 3:10 a.m. when she and Bethany went upstairs to Kaylee's room and the moment police arrived is qualified with, I don't know, I'm not sure, or I don't remember. This is not an exaggeration or a generalization. After carefully and repeatedly listening to the interview, I could state for the record that in 127 minutes of recorded statements, Dylan Mortensen expressed doubt about her recollection at least 62 times. Perhaps that's not surprising, since her roommates had just been brutally murdered, but it bears mentioning. Yeah, this is all stuff this is what I remember from that night, she says when asked about her interactions with the killer and events that followed. Again, it's something I don't know if it was real or what happened. This is what I remembered. Something that could be real, some of it could be not. I don't know. This is what I think. I don't remember. It did not help that Mortensen blamed much of her confusion on being drunk when other witnesses found that confusing. On December 1, for example, a woman named Yesenia Rajo called police from the Delta Zeta sorority to report that she saw Mortensen the night of November 12 and Dylan was not drinking. Rajo told police she heard from friends that Dylan was, quote, too drunk to know what happened, end quote, but that could not be correct because she had talked to her friend about being completely sober. Based on seemingly wild disparities in her accounts, it is just as likely that Ann Taylor would have called Dillon to the stand as a witness for the defense. While at it, Taylor would have called any number of the dozen or so experts she hired to poke holes in the prosecution's case. Criminologists, like former Special Agent Chris Holland, would have stated that police found zero physical evidence of the crimes in Koberger's apartment, found zero evidence in a storage unit, zero evidence in his Elantra, which they disassembled completely. Other experts would have testified that police found no personal or social media connections between Koberger and Kaylee Goncalves or Maddie Mogan, the targets of these premeditated attacks. Behavioralists would have pointed to overkill and signature wounds as proof of rage as a motive, something no one could tie to a stranger. The defense would certainly have called Dr. Brett Turvey to attack Paulette Sutton's testimony with vigor and zeal. Based on what he has stated here in this book, it seems likely the veteran of 73 multiple homicide trials would have capitalized on Sutton's possible mistakes, parading a laundry list of apparent stumbles past the jury. Among them, he would have highlighted the likely missteps, matching photos to exhibits, drawing conclusions without examining actual physical evidence, opining that Koberger could have escaped the crime scene without tracking blood to his car if he was naked. There was no way to guess how closing arguments would have gone, because a trial this complex could have taken 10 weeks or more, and based on what we know, and we don't know much, there would have been plenty of drama and surprises. That's the way these things go. In the end, it would all have gone to the jury, and at that point, one guess is as good as another. Everyone knows a grand jury will indict a ham sandwich, but as Mark Twain once quipped, a jury consists of 12 persons, chosen to decide who has the better lawyer. In this case, it was no Johnny Cochran. But none of that matters, of course, because regardless of what we believe or think we know about what happened around 4 a.m. on November 13 at 1122 King Road, one thing is certain. On July 2nd, 2025, Brian Christopher Koberger stood in front of Judge Stephen Hippler and pleaded guilty to 1 count of burglary and 4 counts of premeditated murder. After nearly 3 years of steadfast denial, he changed his mind and took a plea. The only question that remains is why. Why would a man confess to something he may not have done, knowing he was going to spend the rest of his life in prison with no possibility of parole? Only 2 people know the answer: Koberger and his attorney, Ann Taylor. As luck would have it, we have first-hand insights into her thinking. She called it the new normal, a source told me during a face-to-face interview in October 2025. She said it was exhausting working with Koberger to make a decision once the actual offer came in from Bill Thompson's office. She said the whole thing was like getting ready at an amusement park for a giant roller coaster and then getting pulled out of line just before getting to the gate. In July 2025, approximately 1 week after Koberger changed his plea to guilty, Ann Taylor consented to a call with one of the 24 criminologists and mitigation experts she had hired to poke holes in the prosecution's case. This individual felt strongly that information gathered by the defense was far too compelling to warrant waiver of a trial and wanted to know what had changed. He agreed to discuss recorded conversations with Taylor, but only in general terms, and requested that his name not be used for professional reasons. Before we get into the reasoning behind Koberger's change of plea, let me say I found out just like you and everybody else. I want to make that clear up front. I started to get all these texts from colleagues telling me this case was getting a plea, and I'm like, what? We'd all just had a meeting that previous Wednesday where everyone got together to discuss the case, how everything was coming together. As far as we knew, we were proceeding toward trial. It should be noted that both forensic criminologists, Dr. Brett Turvey and Christopher Holland, expressed shock at the sudden change in direction. Neither had any suspicion of a plea agreement until it was announced in the media. This stuff happens, especially in larger cases, the source said, referring to last-minute deals. But I couldn't believe it, because this wasn't just reasonable doubt. It was overwhelming. I have worked dozens of cases like this during my career, and I was shocked. I think the common impression was that the prosecution had real problems with chain of custody on the K-bar sheath, inconsistencies in DNA testing, holes in Paulette Sutton's analysis, evidence of a second offender. The source said he was so convinced the case was going to trial, he had left a bag full of clothes in Taylor's office. She told me it happened right after the Dateline leak, he said. I had been told that the judge had gotten involved as a mediator between the 2 parties. In my opinion, that's completely inappropriate, so I told her so. But she said once the offer came in from the prosecution, things happened quickly, with no back and forth. She said he told her not to let it out. She couldn't talk about it with anyone except her client. This explained the cloak of silence, but not the reasoning for Koberger's change of heart. She said there was no clear-cut answer, just that they had fought their asses off and filed every motion under the sun. So I asked her directly if she had talked to him, her client, and if she had asked him if he had done it, if she had asked him for any details whatsoever that would explain what happened inside that house. And I'll tell you exactly what she said. She said there was nothing. She had no idea whether he actually did it or not. The source stated that he was led to believe Koberger had been taken to death row to see where he would stay pending execution of sentence, but that Taylor refuted this. She told him another lawyer in her office and a mitigation expert toured the prison, and they explained things to Koberger as he made up his mind. She told me she followed ethical guidelines and talked pros and cons with him, that he read all the reports we had compiled. She told me he talked to the psychologists and his parents leading up to the decision to change his plea, but said the decision was his, that he made the choice for himself. And I'm sure this is probably true, but in the end, what bothers me the most is that she never asked him how or why. She seemingly never asked her client for a single detail about these horrific crimes. She allowed him to plead guilty, knowing he was not going to explain anything in court, that he was not going to explain anything to the parents of those kids, or the investigators who will never be able to put the loose ends together. In my opinion, she watched him stand up in that courtroom and take the plea, perhaps knowing it was broken. If justice is the realm of lawyers and courts, where has that left us? Yes, Brian Christopher Koberger will spend the rest of his life in prison for horrific crimes committed in the early morning hours of November 13, 2022. Yes, the prosecution has moved on to other cases, as has the defense. Yes, Moscow police have returned to their rounds, doing their best to protect the community as their bosses grudgingly disclose bits and pieces of a 51 terabyte file so large it may never be adequately probed. Yes, the survivors are left to try to make sense of senseless horror. The obvious question, of course, is this: where do we go from here? Perhaps it makes sense to look back at where we started and agree that while most stories do not begin at the end, we still don't have one. Perhaps we take it upon ourselves to press the people we pay to protect us for answers. Perhaps we gather together our resources and talents to question what the experts have tried to sell as fact. Perhaps we push forward for truth, because the system we trusted to prove guilt beyond a reasonable doubt has left us all with plenty. Acknowledgements. I'd like to thank my friend and agent, David Villiano, for years of steadfast support. Thank you to Matt Bauer and his remarkable team at HarperCollins for providing the editorial, legal, artistic, and marketing expertise necessary to turn a bunch of pages into a story worth reading. Thanks to my wife, first-line editor, Dr. Rosemarie Whitcomb, for months of research, weeks of proofreading, and years of selfless commitment. It never escapes me that although my name appears on the cover of this book, we share in its production. I am grateful to Dr. Brent Turvey, former FBI agent Christopher Holland, and the two unnamed sources for the courageous and unflinching devotion to truth. Without their expertise, perspectives, and intimate knowledge of the case, details of this terrible story may never have been disclosed. Finally, I want to acknowledge a new generation of amateur sleuths who labor in obscurity, pioneering innovative new techniques to solve cold case investigations, find missing persons, and right wrongful convictions. May this book spur your advances. One last reminder, for access to the reference material, don't forget to download the accompanying enhancement PDF from your audiobook provider. You've been listening to...
Okay. So I want to say this. I've been listening or watching and reading the comments, especially the ones this past few minutes that Jana has posted. And I will say this. It is completely up to the prosecution and the defense as to what information they present to a jury. The reason for all the motions in limine were to prepare for what information could be or would be presented in front of the jury. Unfortunately, the judge has the ultimate say-so as to whether or not he feels that the information either side wants to present is relevant. He shot down every piece of information that would have, in my opinion, been of any benefit to Bryan Kohberger's innocence. When you have a judge who refuses to acknowledge anything that the defense tries to present in order to defend their client, it is impossible for that client to get a fair trial. And if you've watched all of the preliminary hearings and read all of the motions in limine, it is very obvious that Hippler was 1,000% biased. And there was some type of extreme animosity between him and Ann Taylor. It was almost palpable in the courtroom every time she stood before him. Anytime he mentioned her name. I don't know if they have some kind of history. I've said this for 2 years now. I don't know. But something with that relationship was wrong. And in my personal opinion, the reason that Bryan Kohberger took the plea deal is because he knew he wasn't going to get a fair trial. Because all of this information was not going to be presented. And if you're in the legal field, then you should know very well that only the information that the prosecution wanted to be presented to the jury is what was going to be presented. And they were going to try to twist anything that the defense came up with. And when you have a judge who's also tying the defense attorney's hands at every turn as to what she can or cannot present to a jury, they would never have found him not guilty at trial because they wouldn't have had the evidence to do so. You've got the prosecution publicly saying that Bryan Kohberger's DNA is on the knife sheath, and we now know it wasn't. That literally was their biggest piece of evidence, their only piece of evidence that connected him to that house. They don't have positive identification of the vehicle. The cell phone records are not 100% accurate. So all you have are a few cells of DNA that do not even connect directly to Bryan Kohberger, just through some genealogical testing. Okay, Gina, would you want to risk an appeal in a death sentence penalty case? Really? You would want to risk your life? Fuck that. And it's easy to sit back and say that. It's easy to say, well, I would have just went to court and appealed. Well, what if the appeal doesn't go through because the same crooked ass people who put you in the position you're in are in charge of the damn appeal? That's the most asinine thing I've ever heard of. Look at the percentage of appeals that are granted. Because I know one person right now, Nicholas Godejohn, shouldn't be in prison. His appeal should have been granted based on the evidence of the case, because they didn't show all of the evidence at his trial either. But guess what? He's still sitting there, and they've denied every one of his appeals, and now his appeals are exhausted, and he's fucked. The justice system is fucked because it relies on the people who run it. And if they're crooked, so is the system. We don't know who the four brothers are. Their identity has never been released. It was redacted, and now, miraculously, the information that was sent to the FBI First of all, I will say whatever the fuck I want to. This is my channel. And I've been completely respectful. And if you think this is disrespectful, listen, I don't deal with snowflakes. If you're easily offended and you can't stand some harsh words, then you're on the wrong fucking channel. I'm a realist. I say exactly what I think. I don't sugarcoat shit, and I don't powder people's ass. If that's what you're looking for, you're on the wrong channel. But if you want facts and accurate information, here I am. Now, back to what I was saying. The four brothers, all of their investigative data from both Othram and the Moscow PD was turned over to the FBI. No one has a clue where all of those investigative notes are that contained the four brothers' identity. The only thing that was said in the preliminary hearing on January 23rd is that they were not related to Bryan Kohberger. And I corrected this last night, and I will correct this again. This does not mean that a group of four brothers did this. It means that the DNA that was tested belongs to one of four brothers who have similar DNA. And they contacted one of those brothers and asked them to voluntarily submit DNA to eliminate him. And he said, no, do not contact me again. And they didn't. And then a few days later, the FBI contacts Othram and says, send us all of your information. We're going to finish this investigation. And that was the last time anybody's heard anything about it. And then the FBI gives them Bryan Kohberger's name. Jenna, they don't have to prove anything because Bryan Kohberger had already been tried in the court of public opinion. Every news agency on the planet was reporting about the DNA was his found on the sheath. Him getting a fair trial was never going to happen. And whether or not this man ever gets out of prison or not, even if he did, his life will never be the same. Because the same ignorant, ridiculous, obstinate, willfully ignorant people who argue semantics and stupidity with me on a daily basis are the same people who will always believe that he's guilty, whether the proof is in front of them or not, because they don't really care about proof. They don't really care who is in prison. They don't really care about the victims and who killed them. They just care about arguing and being right. Most of the people who argue about this case don't know one damn thing about it. They don't know a fact. They've never looked at a document. They don't know the actual evidence. Nothing. They know a little bit of what they've heard either online or on the news, and that's what they run with. Hang on just a second, babe. Now, thank you everybody for listening. That was the end of the book. So episode 4, part 4 was the end. I appreciate all of you who took the time to listen to it. I'm glad that y'all were able to listen to the audio. If you couldn't find the book or didn't have the means to do so. And I hope that y'all enjoyed it and got some information for it. It will be continue to be posted here so that if you need to go back and listen to it again, you can. Thank y'all. Have a great afternoon. I will see y'all soon on TikTok.